And we're live.
Hello, and good morning, everyone. Thank you all for joining our webinar this morning for the oral arguments of Mexico versus Smith and Wesson. My name is Christina Delgado, and I am the Southwest Advocacy Associate for Community Justice. We are a national organization led by people of color for people of color, seeking public health approaches to the everyday acts of gun violence and violence in our Black and Brown communities. And I am happy to be here to help guide everyone along with our fabulous panelists um, through the oral arguments. Just a little bit of housekeeping. We want you to be here to listen, to learn, to ask questions, to engage. Absolutely feel free to come and go throughout the webinar. The first half of this webinar is going to be the oral arguments that we will be listening to and being guided by our fabulous legal team of attorneys across the country that'll be here to help us. Um, the community discussion will begin promptly after the oral arguments conclude. Um, and as a organization that works to support survivors, I'd like for us to give just a brief moment of silence in honor of our survivor communities here in the US and with our brothers and sisters across the border. Thank you all for that. So we're going to go ahead and just jump right in and get started. First, we're going to hear from Amanda Berman, who is a leader in Crowell's appellate practice and submitted a brief on behalf of the scholars, in this case, in support of Mexico. Thank you, Amanda. Take it away.
Thank you so much, Christina. So glad to join you all this morning. I'll just give you a very brief sort of thumbnail overview of the case, although I'm sure some of you are quite familiar with it. So this is a case in which Mexico brought claims against Smith& Wesson and other gun manufacturers and members of the industry, alleging that they knowingly aided and abetted unlawful trafficking of weapons to Mexico. Probably the tricky thing about this case is they are trying to plead a claim as an exception to the Protection of Lawful Commerce in Arms Act, which was enacted in 2005 and unfortunately provides pretty broad, protection and immunity to gun manufacturers for the lawful manufacture, distribution, and sale of arms. However, it doesn't protect the unlawful commerce in arms, and that is what Mexico is alleging here. They are alleging that Smith & Wesson and others have taken some deliberate steps to aid and abet the sale of firearms to drug cartels in Mexico, that they are doing so knowingly, but it's not just their knowledge that they have taken certain affirmative steps. For example, Mexico alleged that they deliberately sell their guns to dealers who disproportionately are known to sell to drug cartels in Mexico. They design and manufacture weapons to specifically appeal to users in Mexico and unlawful users in Mexico specifically. And that, of course, they are doing this all to just increase their sales and increase their profits. So at the end of the day, this should be a case that is really just about the pleading standards. And for any non-lawyers out there, by pleading standards, I mean what you have to do to bring a complaint that survives the Rule 12, the first stage of a case, that survives a motion to dismiss. And all you are supposed to have to do is allege facts that, if true, and whether they are true will be decided later through discovery and summary judgment practice and potentially trial. All you're supposed to have to do is plead facts that, if they are true, would show unlawful behavior. And so Mexico's position here, and what you'll hear counsel for Mexico argue today, is that Mexico did that. It alleged not just that these American gun manufacturers know about sales of their products to unlawful users in Mexico, but that they are deliberately taking certain steps to allow those sales to continue and, in fact, to encourage them. And that in doing so, they are violating both state and federal law. And, if they are deliberately aiding and abetting violations of state and federal law, then that should fall within the exception to the PLCAA. The other concept you're going to hear a lot of discussion about today at the arguments is proximate causation. So in order to show a violation or to plead a violation of the PLCAA, they have to show proximate causation, that the alleged unlawful acts by the weapons manufacturers and dealers are proximately causing harm in Mexico and specifically to the Mexican government, since they are the plaintiff in this case. What you'll hear on the other side is you will hear counsel for the manufacturer saying it's not proximate, that they are essentially relying on an 8-step causal chain. And I think Mexico's response to that is going to be that, in fact, no, this is all, yes, there's a causal chain, but that's a normal part of causation. There's to plead an unlawful act, you don't have to show, it was A and then B. You can show that there is a causal chain between the two things. And here we have, unlawful deliberate acts by the weapons manufacturers that are resulting through a clear causal chain in harm in Mexico that the Mexican government then has to address and therefore experiences its own harm. So this should be a case just about what are the pleading standards, have they been met here? It is obviously not just a case about that, because it is a case about, from the perspective of the manufacturers, about gun rights here in the U.S. And the allegations involve gun violence. So of course that is why this case has caught the High Court's attention. I think a lot of folks were surprised when this was taken up by the Supreme Court, because it is at a very early stage. The district court had dismissed the claims, saying that Mexico had not adequately pleaded violations of the PLCAA. They hadn't shown unlawful acts falling within that exception. The First Circuit reversed and said, yes, these allegations are sufficient at this very early stage of the case, and only against some of the plaintiffs, to allow the case to continue. So frankly, it's a little unusual and probably not a great sign that the Supreme Court decided nonetheless to step in at this early stage and consider whether to reverse the First Circuit's decision, which in turn had reversed the district court's decision and was sending the case back down to be heard further. So that's where we stand right now, and I'll pause there to let others jump in and provide some more background and color.
Thank you so much, Amanda, for that great explanation, kind of centering us in what we're going to be learning about today. Next up, we have John Lindsay Poland, who coordinates the Stop U.S. Arms to Mexico project of Global Exchange. His research focuses on firearms trade, police militarization, U.S. foreign military assistance, and respect for human rights, especially in Latin America. He's also the co-director of California Healing Justice for American Friends Service Committee. Take it away, John.
Thank you, Christina, and good morning to my fellow panelists and to everyone here. I'm going to say something about not so much the legal aspects that Amanda covered as the ways that this case has been important for all the other ways that the United States talks about and addresses or doesn't address the violence in Mexico and the overall gun trade. Until this case was filed in August of 2021, the primary conversation about violence in Mexico was about drug traffickers. And the primary conversation about gun violence in the United States was about mass shootings in the United States and maybe about other types of gun violence within the United States. What this case has done has opened up the debate, the conversation, the media coverage, the legislative proposals, the binational relationship between the United States and Mexico to address how violence in Mexico is a key part of the consequences of the U.S. gun market, and that the U.S. gun market is a key contributor to what is going on in Mexico. That we can't just think about the fentanyl trade as the key reason why violence is occurring in Mexico. That we also need to understand migration coming toward the United States as a result of violence that is produced with US sourced weapons. So that narrative conversation, I think, is at least as important as the judicial outcome. As Amanda suggested, the US Supreme Court is a pretty hostile atmosphere to consider these issues. I'm not super optimistic about what the Supreme Court is going to do. We should also remember that there is a second court case that was filed by the government of Mexico against five gun dealers in Arizona for their role in guns that have been trafficked to Mexico. And that case has proceeded to discovery and could be unaffected by whatever happens to this case in the Supreme Court or if it's returned to lower courts. Um, so uh, the one of the things we're likely to hear today is going to be arguments that, apart from the legal issues that Amanda described, is arguments that the U.S. guns are a very small portion of guns that are recovered in Mexico. And in fact, in December, the gun industry, supported by some of the U.S. state governments, submitted amicus briefs with old, erroneous data claiming that a very small portion of guns come from the United States, that guns that come from other countries and are recovered in Mexico are not even submitted for tracing, that the number of homicides in Mexico declined after the U.S. assault weapons ban expired in 2004. And in fact, the opposite is true. And a number of our organizations and social scientists and law enforcement officers and state governments within the U.S. submitted briefs that responded to the gun industry's claims, both those factual claims or counterfactual claims, as well as their legal arguments. And so it'll be important as we listen to the Supreme Court arguments to also hear what are the narrative claims, because this is part of the conversation that's going to continue after this case. This case could go on for a long time, or it could be shut down. But the conversation about what causes violence in Mexico, what is driving people to leave their home countries, whether that's Mexico or another country, what is empowering fentanyl trafficking and other illicit substances trafficking organizations? What is producing more than 100,000 forced disappearances in Mexico? As well as what are the consequences within the United States, within our own country, for this wide open, massive, militarized gun market? And that conversation has assertions within it, right? So the gun industry is asserting that they have nothing to do with this, that the fact that there are more than 7,000 gun dealers in U.S. border states with Mexico, that you can buy a 50 caliber rifle without a background check at a gun show in San Antonio or Phoenix, has nothing to do with the fact that violence is empowered, that gun cartels contest state power within a number of different regions in Mexico, thus facilitating all of the issues that the Trump administration, as well as the gun industry, have been decrying over the last years. So I'm gonna leave it there. I'm sure as these conversations, as the arguments are being described, articulated to the Supreme Court, we will have comments in the chat. I encourage you all to put your own questions in the Q&A. We'll try to respond to them, and we may have our own comments as the arguments go forward.
Thank you so much for that information and that background, John. I really feel like everybody's going to be super grounded in what we're going to learn about today with the Supreme Court. So next, we also have My friend Ryan Bussey, who's a former firearms executive who helped build one of the world's most iconic gun companies and was nominated multiple times by industry colleagues for the prestigious Shooting Industry Person of the Year award. In 2021, he published Gunfight, his highly acclaimed memoir about his life in the gun industry. Ryan is a national leader in the fight against radicalization. He is a champion of democracy and was the 2024 Democratic nominee for governor in his home state of Montana. Take it away, Ryan.
Hey, thanks, Christina. Always good to see you. Your smile brightens the day. What I'm going to talk about here briefly, I'm not an attorney. I I don't even know what many of the terms John and Amanda referenced are. I don't claim to be expert in any of those areas, but um, I am knowledgeable in the way firearms are marketed. I'll stipulate right up front, I'm a firearms owner. I shoot and hunt every chance I get. My boys shoot and hunt with me. I believe in firearms ownership and the rights to do so. And I'm also deeply troubled by irresponsibility in the way firearms are marketed and the way our system has been pressurized. And I think that plays into this case. So I'm going to show you just a really quick sort of run through of some slides to give you an idea. I think also John and Amanda also hit on the ways in which U.S. politics, as much as we'd all like to be done with them, probably do weave through this case and in the Supreme Court sort of mindset and decision. Certainly some of the justices, I think, understand the troubling images that I'm going to show you. And I'm just going to start now. I think, there you go. Let's go to that first one. So I got in the industry in 1995. It was large. I was a farm kid, a ranch kid, loved to hunt and shoot. Never thought I would be in an industry where really deeply irresponsible marketing was taking place. That's not the industry I got into. In about 2012, that started to change. This is the first big advertising campaign that told me and that indicated to the world that the way firearms were marketed and the way the gun industry was going to pressurize the system was changing. So this is referred to as the man card campaign. It's the Bushmaster XM15. You can see, I won't go into it, but if you, this kind of toxic bro culture that we have now, well, it was foretold and encouraged with what you see here. You actually got a man card in the mail when you purchased this gun. On to the next slide. Um, my point here, and what you're going to see, is that these marketing campaigns lead to very direct actions and outcomes, some of them disastrous. This is the rifle that was used on December 14th, 2012 in Sandy Hook. So not long after the marketing campaign started, of course, a troubled young man with a man card used that gun in a very disastrous way. So we see that marketing campaigns lead to bad outcomes. On to the next slide. Here we have an example a few years later. This was a huge wall banner and a quite infamous or famous marketing campaign inside the firearms industry that, again, this is 2 years before 2020, the year that most of us lived through, where we saw protests in many cities, George Floyd, all that sort of stuff. So this is foretelling 2 years prior to 2020. This is a firearms maker in Miami, Florida. When I got into the industry, there were 1 or 2 or 3 AR-15 manufacturers of any size. Today, there are about 500. Spikes Tactical in Miami is one of them. And you see here, they're foretelling what's going to come down the pike 2 years later, that Berkeley, Portland, Charlottesville, Boston, not today, Antifa, you see. And you see there's a very particular way these guys are dressed. T-shirts, backwards ball caps, jeans, AR-15s, all of them. If we go on to the next slide. Here you have 2 years later, a kid with jeans, a T-shirt, a backwards ball cap, and AR-15 is following through on that marketing. So the industry has decided at this point that it's going to do whatever it can. It's going to use politics. It's going to become completely devoted to the radicalization and right-wing politics, and it's going to use that to pressurize the system. And if bad outcomes come of it, so what? On to the next slide. If I think this sort of plays into this case too, because the industry has never been shy since about that 2015, 16, 17 range of admitting that these are guns marketed to military and police units. So it's a militarization, not just of law enforcement, but of the general public and of firearms dealers. And here you have a famous ad, Daniel Defense, which is a firearms maker that emerged. It's one of the AR-15 makers that emerged in all of this blow up. And here they're marked, one of their first ads, use what they use. So what the special forces use, you can go down and buy. On to the next slide. Just a couple years after PLACA was passed, which Amanda noted, you have the largest manufacturers in the United States started to get into this militarization and pressurization game. Here you have Smith & Wesson introduced this rifle in 2006, and it is the M&P rifle. They have about 30 or 40 pistols that are M&P as well. M&P stands for military and police, so marketed to the general public in a very overt way. If you want to use, or in the case of many Mexican cartels, if you want to fight the military and police, you should carry what the military and police carry. And here you have Smith & Wesson selling a military and police gun. It's literally called the M&P 15, and it's the best-selling rifle in the United States. On to the next slide. Here you have Daniel Defense, the same company we referenced just a little bit ago. They're marketing these guns through getting them placed in big video games like Call of Duty. Here you have Daniel Defense celebrating that placement in a video game. On to the next slide. This was Daniel Defense's ad. This was their social media post on the day of the Uvalde shooting. This is a DD-M4 V7 rifle held by the toddler there. And so my point in showing you this is that there really is no limit to the degree to which a firearms company will go to sell or pressurize the system. I think this is deeply irresponsible. I think that they know it's deeply irresponsible. I don't think they care. If you pressurize this system enough, leaks sprout out. Some of them are discussed in this case. I just want you to see that the limit to which they will go, well, perhaps there is no limit, right? Here it is. On to the next slide. There are even now firearms companies who are marketing guns and pressurizing the system in a way where democracy itself and good governance is overthrown. A rooftop shooter or voting from the rooftops is an industry slang for somebody who doesn't get what they want in an election and they get up on a rooftop and they vote from the rooftop. And you see there on the right, that's a young man at a firearms rally in Virginia proudly donning a rooftop voter jacket. So he's saying, I don't get what I want. I get up on a roof and I take care of business. And the example on the left here is actually a firearms company, one of the 500 making AR-15s, named Rooftop Arms. So they're marketing to this. Again, an example of pressurizing the system. On to the next slide. This is a rifle. It's just a capture of a web page, one of the most high-end and famous firearms companies in the industry now, marketing an urban super sniper. These guns obviously can be purchased, and if you're wanting to fight urban warfare in any city in United States or Mexico, perhaps an urban super sniper is what you want. I think this sort of direct marketing is not responsible at all. But it's just an example of pressurizing the system. On to the next slide. I'm just about done here. Here you have ways in which this is a POF USA. They're marketing, if those of you saw or experienced January 6th, this looks very familiar, right? So US politics are deeply intertwined with the way firearms are marketed. And I think, there are probably some Supreme Court justices who are somewhat sympathetic to this kind of marketing. I'm not, but take that into account as you hear the arguments today. On to the next slide. If you talk about marketing to young men, here you have natural male enhancement. This is a suppressor. Some people call it a silencer. And you have Donald Trump Jr. there on the right speaking with the owner of this company. This is how they're marketing to young men. On to the next slide. Here you have Smith & Wesson actually tapping into domestic strife here, not shying away from what I think is deeply irresponsible marketing. You have these are actually Proud Boys. They're a domestic terror organization. Those are pictures of Proud Boys on the left. And then you have Smith & Wesson's social media post where they develop they're not called Proud Boys. They spin it off in kind of a cute wink, wink way. They call it Preception brand, but they use all of the Proud Boys iconography, right? Support your local enforcer. These are shirts and hats that they sell to tap into to the Proud Boys sort of imagery. On to the next slide. Here you have a big AR-15 company marketing directly to 3%ers. So if you want to be a domestic terrorist, supposedly in this country or another country, here you have a gun company saying, "Yep, we have your gun for you. We're marketing directly to domestic terrorists." On to the next slide. And then this is just the firearms industry, one of probably about 100 now. Donald Trump Jr. 40 or Donald Trump 47. Firearms specifically developed and marketed towards celebration of the recent election we have here. So all of this is political. Again, I think it's irresponsible, but it should give you an idea of how the industry here in the United States markets and sees its it believes its responsibility to pressurize the system however it can and win in politics and policy however it can. And so here we are today. That's all I've got.
Thank you so much, Ryan, for all of that background. I think it's really incredible to be able to really bring this home and center us in both the marketing portion, the advocacy portion, and really bringing in folks who kind of have a different type of skin in the game. Because we know that a lot of these policies to try and prevent these things from happening, preventing the gun trafficking, preventing the mass shootings, preventing the community violence, are all supported by quite a bit of the gun owning community. I come from a gun owning family, and these are fundamentals of the responsibility that we have in practicing the Second Amendment. So thank you so much, Ryan, for that background. And definitely, I think there will likely be some questions, as we proceed into the oral arguments that should be starting anytime now. Sometimes they get started a little bit late, but we could do some quick, if anybody has any questions that they'd like to put in the chat, or I'm sorry, in the Q&A, we could definitely, answer any questions that you may have about what you've already heard from our panelists. And I think leading up to it, we also have Paul Friedman, who is here, who is a part of our gun violence prevention community. So Paul, if you have any additional comments that you'd like to give, that would be helpful too.
Well, it's great to be here. And am I on video? Not
No.
We cannot see you. You're not on video.
That's all right. Well, so I'm the executive director of Safer Country, a gun violence prevention group in Alexandria, Virginia, and I'm a lawyer. I thought the presentation at the start was excellent, describing the setup. And I just want to maybe highlight for folks that the question about whether the manufacturers of these guns are aiding and abetting what's happening, the violence in Mexico, that's probably going to be a critical area to watch for and to listen for during the hearing, because a key case is going to define what that means, what aid and abet means. And that case is called Twitter versus Tarmney. It's a 2023 case. It hasn't had a lot of time to be assessed. Here I am. And it's rather vague in terms of its holding, but it is a case regarding social media, Twitter, and videos that are put up on Twitter that could lead to terrorism, and whether Twitter should be held accountable. And the court found unanimously that it shouldn't be. They felt it was too far afield to suggest that that actually aided and abetted terrorism. But here we have gun manufacturers and gun violence. This is a much stronger case for aiding and abetting. But of course, this will be up to the Supreme Court. And if the court is looking to find a reason not to rule in favor of the Mexican government. This is going to probably be the area they will uh, seek to do it in and try to distinguish and use that Twitter case to be able to somehow make the case that they're not aiding and abetting the violence in Mexico. So I'll stop there for a moment.
So I see your question here about the gun advertisements. I don't want to frighten the hell out of you, but I'm going to. Those are like 10 slides out of 150 I have on this computer that I'm using this morning, and there's more all the time. The answer at current is to your question is, are there any, the question is, are there any laws limiting these horrific ad campaigns? No, and we're trying to sort out what the laws and liability are. That's part of this case and other cases. I think many of these things are immoral for sure. Sadly, I'm not real sure if they're illegal or not, and so that's what we're trying to figure out. But they're getting worse. There was a collapsible sniper rifle introduced this year at the SHOT Show, which is the industry trade show, and it's proudly marketed as like, have a briefcase, throw a sniper rifle in there, super accurate out to about 900 yards. So it's just proudly marketed. Anybody can buy that. This side of the border, south side of the border,
Well, let's talk just for a moment about what's at stake here. PLACA, for the last 20 years, has essentially barred the ability to sue these gun manufacturers and hold them accountable and get damages, financial damages, for their production of these highly dangerous weapons and their marketing, which you've just seen, which is so encouraging to people to use in illegal ways. If this case were to be successful for the Mexican government, it would very likely be an opening that would help here in America for a variety of ways to be able to attack and get through, puncture PLACA in order to provide more ways to get damages. And so this is going to be a very important case. And it's one of the reasons that they're doing so much on the gun manufacturer's side, investing so much money in fighting this case and hoping that this generally considered conservative court, 6-3, will stand with them regardless of whether the law is with them or not. And because there's so much at stake for these companies.
I can briefly address what I think is a still pending question about whether the designation of the cartels as terrorist organizations is going to have an impact on the arguments today. My suspicion is that we will hear that said at least once. I don't think it's going to change the outcome either way. I think, though, if the case continues, Mexico is likely going to want to revise and add to its allegations as it goes back down to pursue this case, because that might implicate some other legal violations that they could assert against the gun manufacturers. So I think we'll hear it mentioned today. I don't think it's going to impact the outcome of this case. But certainly adds some color. And I think, as somebody said, this case is just part of a conversation that's going on right now between the United States and Mexico at a very high level. Claudia Scheinbaum has commented on this case. I think she even said that that designation may add to their claims here. So I think if it goes back down, it'll play into it.
So Amanda, go ahead. I'm sorry.
I can also add to that. Mexico has wanted to, in the bilateral relationship, has wanted to keep certain issues on certain tracks, right? So the trade agreement, keep it talking about trade. The migration conversation, keep it talking about migration. The firearms control, keep that on a certain track. And the Trump administration has been eager to mix them, right? Okay, so we will do this if you do that, or we won't do this. You have to do this in order to. And so that's been very clear publicly as well as in the private conversations. And I think at this point, Mexico is recognizing that they can't keep these things on separate
Oral
tracks.
arguments have started.
Firearms to licensed distributors who sell to licensed retailers, a small percentage of whom sell to straw purchasers, some of whom transfer to smugglers who then smuggle them into Mexico, hand them over to cartels, who in turn use them to commit murder and mayhem, all of which requires the government of Mexico to spend money.
Can everybody hear?
Needless to say, no case in American history supports that theory, and it's squarely foreclosed by the Protection of Lawful Commerce in Arms Act. As to proximate cause, this court has repeatedly said there must be a direct relationship between the defendant's conduct and the plaintiff's injury. But no such relationship exists if plaintiff's injury is caused by multiple intervening independent crimes committed by foreign criminals on foreign soil to inflict harm on a foreign sovereign. As to aiding and abetting, Mexico doesn't identify a specific crime, criminal, or criminal enterprise that defendants supposedly helped. Instead, it asserts that defendants are liable for every illegal sale by every retailer in America because they know that a small percentage of firearms are sold illegally and don't do more to stop it. Again, no case in history supports that theory. Indeed, if Mexico is right, then every law enforcement organization in America has missed the largest criminal conspiracy in history operating right under their nose, and Budweiser is liable for every accident caused by underage drinkers, since it knows that teenagers will buy beer, drive drunk, and crash. The First Circuit gravely erred in embracing that implausible theory and should be reversed. I welcome your questions.
Mr. Francisco, as to the predicate exception, which federal or state law is petitioner reputed to have violated?
So my understanding, Your Honor, is that they're invoking the federal aiding and abetting statute to argue that we have aided and abetted the federal statutes that govern the sale of firearms, and they're alleging that retailers have knowingly sold firearms to straw purchasers and that we aided and abetting that knowing sale. That actually raises a very important question about their allegation of knowing. I don't think it's relevant because I'm willing to even assume a certain level of knowledge. I don't think it matters. But their theory of knowledge is that we actually know that retailers are selling illegally. I'd actually urge you to look at that 2010 Washington Post article that they incorporate into their complaint. That article talks about a particular retailer called Lone Wolf. In 2010, it was the #1 seller of firearms that were found in Mexican crime gun scenes. And in that article, you actually have a quote from ATF that says that ATF has no basis to believe that Lone Wolf is doing anything illegal or wrong. Well, if the government doesn't know, how are we supposed to know? It reflects this convoluted theory that simply because the gun is found in Mexico can be traced back to a retailer. That means the retailer necessarily sold it illegally and that we know that the retailer sold it illegally.
Would this be a different case if there was a specific federal or state statute that you were known to have violated?
Your Honor, it would be a different case. I would want to know more because I still think that depending on what they alleged, I would have very strong arguments on proximate cause and aiding and abetting liability, but it would certainly be a different case.
Well, the reason I ask is because the exception is for knowingly violating a state or federal statute, and it would seem helpful in determining aiding and abetting and then eventually proximate cause if that comes up, if you knew which statute we were dealing with.
So the complaint is a little bit vague on this. To the extent I understand it, they're looking at federal statutes that restrict the knowing sale of firearms to people who aren't authorized to purchase them. And then they're invoking the criminal federal aiding and abetting statute to claim that we're then liable for those illegal sales. I'm willing to assume, for the sake of argument, that that's valid because I don't think they come anywhere close to establishing aiding and abetting liability. And even if they did, I don't think they come anywhere close to establishing proximate cause.
I'm sorry, counsel, but exactly what role, I had difficulty telling from your brief, does foreseeability play in your proximate cause analysis?
So as this court has made clear in a number of cases, it's not that foreseeability is irrelevant. It's that foreseeability alone is not the standard. So it's necessary but not sufficient. In addition, there has to be a direct relationship between the defendant's conduct and the plaintiff's injury. And Your Honor, I think that the plurality opinion you authored in the Hemi group is directly on point. That is where a case where the plurality held that the city of New York couldn't sue a cigarette retailer for not filing the tax reports in order for the city to recover its lost tax revenue, because in between the city's injury of lost tax revenue and the retailer's failure to file the reports stood the citizens of New York who illegally failed to pay their taxes. And that broke the chain. This is a much easier case. Here we don't have just one intervening independent crime. We have a multitude of intervening independent crimes. So even if they could establish aiding and abetting liability, and I don't think they come even close under Twitter, they couldn't establish proximate cause, which is the other requirement here.
Counselor, it seems to me that the cases are a mess on proximate cause. And you're asking us in this case to choose among a variety of different explanations of it. I think, however, I try to break this down. I think their complaint is saying that the violation is selling to straw purchasers. And I think the risk in selling to a straw purchaser, and that's the known risk of that violation, is that that straw purchaser is giving or selling the gun to someone who can't possess it because the likelihood is that they're going to use that gun illegally. And that's the risk of the violation. And I think that that's what their complaint says, which is, now, I'm going to put aside the lack of the conclusory allegations, and I agree with your point that they don't really tell us which dealers are doing this, who they're aiding and abetting. There may be a lot of conclusory allegations, but the theory, I think, that they're advocating is if you're selling to a straw purchaser, that's, you know, that the risk is that they're giving it or selling it to people who are going to commit crimes. Here, the Mexican cartel. So I don't know if this is a proximate cause case or it really is what you say it's not, or that the allegations are insufficient for aiding and abetting. I think for us to go into proximate cause opens up a Pandora's box.
So I want to take one step back, Your Honor, because they're not alleging that my clients engaged in any illegal retail sale. None of my clients actually sell to consumers.
No, the complaint says they aided and abetted. Justice Thomas asks you, what violation? I believe the violation they claim is that the dealers are selling to straw buyers.
Sure. And I just wanted to be clear that I think that the chain of causation, I think it's relevant both to proximate cause and aiding and abetting. I think that the chain of causation under the statute doesn't start at the illegal sale because we aren't alleged to have engaged in an illegal sale. It starts with the conduct that they allege constitutes aiding and abetting the illegal sale, which is the way that we manufacture and distribute our firearms. But I also think that's relevant to aiding and abetting liability because we're not alleged to have aided and abetted any cartels or any illegal purchaser. We're alleged, in this case at least as they presented it here, to have aided and abetted the retailers. And so they have to carry the argument that somehow we're liable for every illegal retail sale in America because we know that some small percentage of retailers may sell the firearms illegally and don't do more. Now I dispute
Mr.
that.
Francisco, I just want to pause there for a second. Sorry to interrupt you, but Just to follow up on Justice Sotomayor's question, put aside aiding and abetting, assume for the moment that you did aid and abet the sales, your clients aided and abetted the sale of guns to bad apple dealers, ones they knew or intended to even for them to sell on to people in Mexico doing bad things. They knew that. They knew all of that. How would you not have proximate cause in that hypothetical?
So, sure, Your Honor, and that is a huge assumption. But even accepting that assumption, for the same reason there was no proximate cause in Hemi Group. Even if you assume that we're on the hook for that illegal retail sale, you still have a multitude of independent crimes in between that sale and injury to Mexico. You have the straw purchaser that gives it to the actual purchaser. You have a smuggle across an international border.
I understand, but my hypothetical assumes that you know all that. Your clients know all of that, maybe even intend it. Now, whether there are allegations of this complaint sufficient, put that aside. But if you know or intend all of that, then what?
I still don't think that establishes proximate cause when you have an intervening independent crime. And I'll point you to Hemi Group, Your Honor.
Oh, yeah.
In Hemi Group, the underlying statute was the filing of the tax reports. The entire purpose of the tax reports was to allow governmental entities to collect tax revenue from cigarette sales online that weren't otherwise subject to sales taxes. But the plurality held that that independent intervening act still broke proximate cause. I think it goes back to the court's 1876 decision in the St. Paul Railway case, where you made clear that if there is a sufficient and independent
Wasn't
cause... Your Honor, I think of the court as a collective body that operates across time. And it made clear...
Gorsuch doesn't believe that.
Yes, I do.
And it made quite clear way back in 1876 when you do have that, and I'm quoting, a sufficient and independent cause operating between the wrong and the injury, that does break the chain of causation, even if it's eminently foreseeable. Just like many, many, many years later in the Hemi Group case, the court concluded the same, even though it was eminently foreseeable that the retailer's failure to file the tax reports could lead to lost tax revenue.
Mr. Francisco, can I just put a point on this, because I want to make sure I understand the line of questions you've been asked. So it seems to me, as Justice Thomas began, that when we're talking about the statute that was the violation at the beginning for the predicate, it has to be a statute that was specifically applicable to the sale or marketing of the product, the gun.
Yes.
Justice Sotomayor asked you, so that's the retailer selling it to the bad guy, right?
Yes.
Okay. That's where the proximate cause inquiry comes in. Your client, the theory, right? The theory is that your client under example 2, has aided and abetted as the manufacturer. Proximate cause doesn't appear in that portion of the statute. It's only in the predicate portion. So if we accept that framing of the theory, the framing of the complaint, we're really only asking about proximate cause, as Justice Gorsuch was asking you, between the retailer, the sale, and the harm ultimately caused to Mexico. And then we're looking at the chain of events that you're talking at right now. Sale to the bad guy, smuggled across the border, misuse.
So I think I have two responses, Your Honor. The first is I actually disagree with how you framed it, but the second is, even if I accept how you framed it, I still think there's no proximate cause. The statute says that there has to be proximate cause between our violation and Mexico's injury. Our violation is not the illegal sale itself. It's the actions that we undertake to aid and abet it, the violative aiding and abetting conduct.
How does that fit in the statute, though?
Your Honor, because I think the statute says the statute requires that, sets forth the exception where a seller has knowingly violated an applicable statute and the violation, referring to the seller's violation. But it's not just applicable statute, it's statute applicable to the sale or marketing of the product. So that seems to me to refer to a specific statute relating to this manufacture, sale, distribution of guns, not the aiding and abetting statute. Well, I think it's got to refer to our violation. It refers back to the seller's violation. And here the seller hasn't specifically, and this maybe goes to the confusion that Justice Thomas pointed out, but the seller's violation is not the actual retail sale. We're not retail sellers. Right. The seller's violation here is the aiding and abetting of that retail sale. And I presume what they are invoking is the federal aiding and abetting statute, and they're trying to combine that with the actual specific sale. So I think there are all kinds of problems with their theory.
I guess I don't get that, Mr. Francisco. I mean, aiding and abetting is a form of vicarious liability. Why wouldn't you just say the aiding and abetting violation is the violation that is aided and abetted, which here, as Justice Barrett said, is the retail sale, say the sale to a straw purchaser?
Sure, Your Honor. I think I'm just trying to construct the statute properly, and I think as a matter of proper statutory construction, that's where you begin the proximate cause with our violation. But I don't really want to fight about it.
But your violation, as a matter of vicarious liability, is the violation that the retail seller it sells to the straw purchaser.
Your Honor, I'm not sure that's right, but again, I'm willing to assume for the sake of argument that it is right, because I still think that there's no proximate cause in between between the illegal retail sale and Mexico's injury off in Mexico, and I sure don't think that they've come anywhere close to establishing aiding and abetting liability. I've already explained why I think there are multiple independent crimes after the retail sale, in addition to the smuggle across an international border and the murder and mayhem committed independently by cartels in Mexico. To me, that is more than sufficient to break that chain. But in any event, I think that their theory of aiding and abetting liability is equally far-fetched. I think this is...
So with reference to aiding and abetting, could you just explain to me the sort of structure of this industry? Who are these distributors? Are they pass-through entities? Are they completely independent? Might they be both? What's the...
They're independent entities, Your Honor. It's possible that there might be some internal distribution, but by and large, a manufacturer makes the firearms. Then there are distributors who purchase the firearms from different manufacturers. Those distributors then sell firearms to retailers. Everyone in this chain is fully licensed. The retailers then are fully licensed and they sell to purchasers. The allegation is some small percentage of those sales are illegal, and we know it.
Is your representation that the manufacturers really only deal with the distributors, or do you understand the manufacturers to be looking at and paying attention to the dealers too?
Well, Your Honor, we're here on the complaint, and as far as the complaint alleges, it's simply the manufacturers going to the distributors going to the retailers.
Right, I'm asking from what you know of the industry and your client. Is the manufacturer essentially dealing with the dealers, or is there like a big roadblock?
All right, so
which is in the form of the distributors?
We're outside of the complaint now, so I want to be very careful because I don't 100% know the answer to all of your question, but my understanding is that the manufacturers are not generally dealing with the retailers. You do have this tiered distribution chain where they're principally dealing with the distributors to the retailers, and so on. I think that the reason this is such an implausible aiding and abetting theory is because I actually think this case is a lot easier than the Twitter case in a number of different respects. First of all, Twitter, you actually had a specific criminal, ISIS. You had a specific crime, the Reina nightclub attack, and the defendants were actually providing that product to that criminal. You don't have any of that here. Instead, their theory is that by simply knowing that some percentage of retailers may be doing something illegal, that somehow puts us on the hook for everything that the retailers are doing. This is kind of a common law area. You'd think that they could cite one case that comes anywhere close to that, but they don't cite a single case.
Mr. Francisco, that's sort of what I'm a little confused about and I wanted to focus on, which is, it seems to me that the core of your argument, both here and in your brief, has been that there's an implausible theory of aiding and abetting liability based on what they've alleged, and no case in American history supports this theory of liability, as if the question before us is evaluating the viability of Mexico's theory. And what I'm looking at is a statute that I think really makes this case about the scope of the predicate exception, that it's not really, an invitation to assess as a common law matter whether or not we think these facts allege aiding and abetting liability. Would you agree with me that the PLICA statute takes off the table theories of tort with respect to these kinds of manufacturers, and really the only question is whether the statutory exception applies in this situation.
Well, I think I would agree that we're arguing about what the meaning of the statute is, but the statute can only be triggered if they find a violation that's the proximate cause. Here, the violation that they've identified as
I understand, but that
aiding and
proximate
abetting.
cause analysis is coming up in the context of an exception to the immunity that Congress has set forth. Is that right?
Sure, yeah.
And I think that's important because the scope of that exception may not be coterminous with our understanding of aiding and abetting liability as a common law principle. In other words, you look at Twitter, for example, and you say, okay, is this, what is being alleged here the same as aiding and abetting liability as it was set forth in that statute? That was a totally different statutory scheme. That statute, JASTA, in the Twitter case, was about allowing for these kinds of claims. And so what counts for aiding and abetting liability in Twitter may not be what Congress intended for this exception. I feel like we have to focus on where we actually are in this context in making this determination.
Well, Your Honor, I think that's where I might very much disagree with the theory that you're articulating. I think that they do have to show a violation. They've alleged it's aiding and abetting. There's no aiding and abetting in the air. What Twitter purported to do was look at traditional aiding and abetting principles.
Well, I understand, but Twitter was a different kind of statute. We have said that, you know, when we're doing statutory interpretation, when we're thinking about aiding and abetting liability, it may not be the same in every statutory scheme. And I guess what I'm just trying to, I mean, this is not supposed to be like a statement that is necessarily against your position. I'm just trying to understand the framing of this. It seems to me this is a statutory interpretation question about the meaning of what the predicate exception says, knowingly violated a state or federal statute. Aiding and abetting is in the examples. It's not even in the actual core statutory statement of what would qualify. So shouldn't we be focused more on trying to understand what Congress meant when it was accepting, you say narrowly, a certain kind of claim?
Well, Your Honor, to the extent I understand what you're getting at, first, I do think that you really do have to grapple with the aiding and abetting liability issue, and Twitter sets out the framework. But even if you want to take a step back and look at what Congress was getting at more broadly, Congress's entire purpose was to prohibit lawsuits just like this one. It was trying to prohibit lawsuits that had been brought by the city of Chicago, the city of Cincinnati, the city of Boston on theories and seeking relief exactly like this one. So if you adopt my friend's position on the other side, you have essentially gutted PLACA. And remember what the larger purpose of PLACA was. It was actually to ultimately protect Second Amendment rights by preventing plaintiffs from bankrupting the industry through frivolous lawsuits. After all, the Second Amendment doesn't really mean anything if there's nobody from whom you can buy a firearm. So I'm willing to take...
just to follow up on this, PLACA, as you call it, says that you've got to show a violation of a state or federal statute. And Justice Thomas asked you, and I'm still not sure we've completely identified what that statute is. I think it's 18 U.S.C. 922, maybe 923. You agree with that?
What's that? Your Honor,
we don't know.
I don't think the complaint was clear on it. We did speculate about that. We speculated about it in our brief. I think that might be the statute.
And then trading and abetting would be 18 U.S.C. Section 2, I think.
I think that's right, yeah.
Okay. All right. I just want to be clear on what is being alleged. And then your friends on the other side make a good point about our precedent in direct sales, which I did not write either and is about 80 years old, too. I want to give you an opportunity to respond to that.
Sure. I will agree with them on one point, that direct sales is their single best case, and direct sales isn't even close. In direct sales, you had a manufacturer that was selling to a specific doctor in such massive quantities that there was no possible lawful explanation. And in addition, the manufacturer then further encouraged that doctor to buy more by offering it massive discounts on bulk purchases. So to use the language of Twitter, you had both a very high degree of scienter and a very high degree of conduct and encouragement.
Well,
nothing like that here.
That raises another question I had, and then I'll stop. But in terms of aiding and abetting under Section 2 for 922, if that's what we're talking about, those are criminal statutes. And Roseman says that aiding and abetting in the criminal arena generally requires intent, not knowledge. But you didn't make anything of that.
Well, Your Honor, I think that because they don't come anywhere close on any standard, whether you call it knowledge, whether you call it intent. Remember, in Roseman, the defendant was actually part of the drug transaction. The question was, did Roseman, in participating in that drug transaction, also know that one of his collaborators was going to shoot somebody? You don't have anything like that here. The other respect in which this is far different from Twitter, in a way that also highlights direct sales, is that in Twitter, the defendants there were far more active. We were here just a few weeks ago talking about algorithms. The way that algorithms work is that they match up the creator's content with the user's interests. So it starts out with ISIS's vile content. It surveys the billions of users on the platform, figures out which ones are actually interested in that content, and puts the two together. We're not doing anything even like that. This is an a fortiori case after Twitter.
Counsel, the complaint says that 2% of the guns manufactured in the United States find their way into Mexico, and I know you dispute that. But is there a number where your legal analysis might have to be altered? If it's 10%, if it's 20%, at some point the proximate cause lines that you draw really can't bear the weight of the ultimate result.
So, Your Honor, I take their complaint as it comes. If we're talking about proximate cause, I don't think that the percentage would actually matter when you have a multitude of intervening independent crimes. In Hemi, for example, I don't think it would matter whether the city was losing, whether everybody was not paying their taxes in New York City or just a small percentage were not paying their taxes in New York City. What mattered is that you had the independent decision of the New York City taxpayers not to pay their taxes that broke that chain. Here you have a multitude of intervening independent crimes, so I don't think that percentage would matter at all on my.
Well, I mean, at some point it must matter. I mean, I understand you don't want your theory about the different steps, but if it ends up that most of your product or whatever number you want to get to a change in your view ends up there, you've got to know that, and if you know that, do you still have to go through the intricate step by step, or can you just say, this is what they make, and pick whatever number you want, 70% of it ends up in Mexico?
I still think you do have to go through that analysis, Your Honor, but even if you disagree with me, I'm willing to accept the allegations in their complaint and the number of 2%, and to be quite confident that that is not enough for proximate cause, particularly when their theory is that simply because a firearm was found in Mexico at a crime scene and can ultimately be traced back to a particular retailer that sold it in the first instance, that means that the retailer illegally sold it and that we knew the retailer illegally sold it. Even the ATF and the federal government rejects that theory.
Thank you. Justice Thomas?
Mr. Francisco, in direct sales, there was exactly that, a direct sale to a doctor. And the seller worked closely with the doctor to work around the limitations. In your brief, you summarized the chain that you've mentioned or alluded to a number of times. Would you just list the chain for our benefit?
Sure. Starts out with a licensed manufacturer, a manufacturer that the federal government says is allowed to make firearms. It then distributes its legal firearms to licensed distributors who the federal government says are allowed to distribute them. They then sell to licensed retailers that the federal government says are allowed to retail. Those retailers, some very small percentage of them, unknown number, but some small percentage of them, transfer those firearms illegally to straw purchasers. The straw purchaser then hands it over to the actual purchaser. You then have a smuggle across an international border, yet another violation of law. The smuggler then presumably gives it to the cartels who are illegally possessing the firearm in Mexico under Mexican law, as my friends have described it. Then the Mexican cartels engage in murder and mayhem against the good people of Mexico, all of which in turn causes the Mexican government to have to spend money to respond to that murder and mayhem. With respect, there's not a single case in history that comes close to that. They don't even cite cases that find a manufacturer, I think, ever liable for the unlawful criminal misuse of its products, other than the cases that PLACA was meant to prohibit, and perhaps other than the Avis case, the Florida Supreme Court case. But they certainly don't cite anything that comes close to that chain of causation, which is more extreme than the cases that PLACA was meant to prohibit.
Justice Alito? Justice Sotomayor? Justice Kagan?
So suppose, Mr. Francisco, and this is not the complaint in this case, so I'm making changes to it. Suppose there's a manufacturer and it deals directly with a network of dealers, or there's a wholesaler and it deals directly with a number of dealers. I think one of the defendants in this case is a wholesaler. Either way, let's assume you have a manufacturer / wholesaler that deals directly with a network of dealers. And suppose that that manufacturer does have knowledge that a particular dealer does more than the usual share of straw transactions, and also knows that more than the usual share of guns wind up in Mexico, and particularly at Mexican crime scenes. So that the manufacturer, in the way that manufacturers do, I think, when they're dealing with dealer networks, they're paying attention to their dealers, and they're trying to figure out whether there's a dealer whose sales are kind of out of kilter with the rest, and they think, yes, I have a dealer whose sales are out of kilter, they're doing more straw transactions, they keep on selling to people who are taking the guns to Mexico, and particularly to people who are leaving the guns at Mexican crime scenes. Is that enough?
Your Honor, that's obviously very different, as you acknowledged. Even in that case, if the manufacturer was simply treating all of the dealers the same, including that dealer, then I don't think you would have crossed the line into aiding and abetting
Treating them the
liability.
same, what does that mean?
So, like say they have a policy that says, look, I sell firearms. Any dealer that wants to purchase my firearms,
I see.
I'm going to sell them to that
Okay, well, they
dealer.
are treating them the same. I mean, from one perspective, that's the problem, that they're treating this rogue dealer the same as the good dealers, right? Even though that they know that the rogue dealer is in fact a rogue dealer. Isn't that enough of a problem to bring you in? And where one thing that's not, that is the same, is that we're at a 12b6 stage.
Sure. And Your Honor, I think I'd invoke Twitter, where the social media platforms knew to a metaphysical certainty that ISIS was on its platform doing nefarious things. And that knowledge to a metaphysical certainty wasn't enough if you were simply treating your customers all the same and you were indifferent to what they were doing. I think this case is a lot easier than Twitter.
Yeah, I
in the
guess that's
various
the question. Is the case that I gave you, is it a Twitter or is it a direct sales? It seems to me more like a direct sales. I'm a manufacturer, I have a dealer network, I know that there's one dealer that's way off the beaten track and doing things that are really different.
Right.
That seems a direct sales.
And if I can explain why I think that direct sales is far more extreme than your hypothetical. Remember, in direct sales, it wasn't just that this doctor was purchasing so much that there was no possible explanation. There was no issue. Nobody even argued about whether the direct sales was treating everybody the same. But in addition, what that manufacturer was doing was explicitly encouraging that doctor, who it was knew was already illegally prescribing, to do it even more. There's an example in the facts, for example, where the doctor orders 2 batches of pills, one for 1,000 pills and another for 100 pills. And direct sales comes back and says, don't do that. I'm just going to cancel your 100 order because I'll sell you another 1,000 pills at this massive discount. So you not only had a high degree of knowledge, you had a very high degree of conduct with the manufacturer actually encouraging
So you think that's
oversale.
necessary to direct sales, that there's a kind of encouragement in addition to a realization that your products are being used in this way for these purposes?
Yeah, I think that's the necessarily implication of Twitter, where you had knowledge to a metaphysical certainty that one of your customers was doing something bad. But what the opinion makes clear is that simple knowledge doesn't get you across the line unless you're in addition acting in an unusual ways.
How about if the conduct is like, and we do this for everybody, don't get me wrong, we do this for everybody, but it's particularly maybe important to Mexican gang members, is that we make it so that you can easily scrape off serial numbers. And we construct a set of products that are obviously useful in their characteristics for cartel members.
Well, Your Honor, the more you ratchet up the facts and make them cartel specific, I think the closer you do get to direct sales.
Those allegations are in this complaint, right? That the manufacturers have basically designed and manufactured a set of weapons with a set of characteristics that are peculiarly useful for criminal activity.
Well, and that's where I don't think you would be getting anywhere close. If we simply make our firearms in a way that the general public likes, and we allow whoever wants to buy our firearms, and we know, as in Twitter, that some percentage of them are going to do something wrong, that's not the type of affirmative action that gives rise to aiding and abetting liability. After all, the social media platforms and Twitter did know that ISIS was on their platform. They were much more active than we are in the ways that I've already described. This court said as a matter of law on a motion to dismiss that that wasn't even close enough because there was no unusual treatment of ISIS relative to any other customer.
Thank you.
And there was no affirmative conduct towards ISIS.
Justice Gorsuch.
Just one question. Is there any reason for us to reach the proximate cause question if we conclude for aiding and abetting that you win?
If you rule for us on aiding and abetting, that will completely dispose of the case. The reason to also address proximate cause is because it's an extraordinarily important issue that I think applies in many different contexts, which is why there's such a broad range of amici in this case that go well beyond the firearms industry. So while you could completely resolve it on aiding and abetting, I would urge you to address proximate cause as well.
Justice Jackson?
So, Mr. Francisco, I'm just trying to understand what you mean by resolve it on aiding and abetting liability. Don't we have to have a conception of aiding and abetting liability that is specific to this statute? You seem to be drawing on others, and I thought we took a statute-by-statute approach to aiding and abetting liability. We've held as much. We've said that before.
Well, Your Honor, in Twitter, you were applying aiding and abetting principles that arose in the context of a murder when you were talking about social media platforms. I think the whole point of Twitter was that there is a set of general aiding and abetting principles, and that is the law that informs what aiding and abetting is. I don't even know how you would do this kind of statute-specific aiding and abetting liability outside of the general principles of aiding and abetting.
I thought we were only looking at aiding and abetting to the extent that Congress mentions that in an example in the statute. So what we're really doing is trying to understand what Congress intended with respect to the exception that it put in this statute. And so to the extent that it references aiding and abetting liability in one of the examples, that is just to illuminate the meaning of the statutory terms that exist there, right? I mean, it's sort of odd to me that suddenly a common law of aiding and abetting liability is coming in to, in your view, be dispositive of how we think about this case.
Sure. Well, I think that it's an example, that the reference to aiding and abetting in the statute is an example of a violation that then triggers the statutory exception and the proximate cause analysis. So you have to understand then what it means to aid and abet a particular crime. Again,
as Congress intended it for the purpose of this statute.
Well, and I think it's not that plausible to say that Congress had some completely idiosyncratic view of what aiding and abetting was for the statute, as opposed to just looking to the principles like this court looked to in Twitter, which are just the basic aiding and abetting.
Can I just ask you about your proximate, can I ask you about the proximate cause? Because I'm still a little confused about where you start your proximate cause analysis. I listened as you discussed with Justice Thomas the steps, the series of steps from your clients to the alleged ultimate harm. But it seemed to me that the first moment of illegality in the chain, that, as you articulated it, was the retailers selling to the straw purchasers. Am I right about that? You say your clients do things that are legal, they sell to other legal buyers, and et cetera, until we get to that straw purchaser point, right?
That is the first moment of illegality, but I don't think that's the sole step relevant to a general proximate cause analysis.
Right, but we don't have a general proximate cause analysis. We have a statute, and the statute makes clear that we're starting with an action in which a manufacturer or seller of a qualified product knowingly violated a state or federal statute applicable to the sale or marketing of the product. So it seems to me that the first step, given this statute, is the moment of violation, of illegality, as opposed to some theoretical original point.
And my answer to that question is no, but it doesn't matter.
No, I understand you think you make it anyway, but I'm just trying to understand why you're insisting that it's way back here.
Because what the statute says is there has to be a proximate cause between the defendant's violation. Our violation is not the illegal sale itself. We don't sell to consumers.
But you say you don't violate at the beginning, so I don't know what your violation is unless it's the point of illegality.
It's the aiding and abetting. That is the whole aiding and abetting theory.
Thank you.
Thank you, counsel.
Thank you, Your Honor.
Ms. Stetson?
Mr. Chief Justice, and may it please the Court, Mexico's complaint pleads that petitioners aided and abetted violations of specific federal gun laws, and that those violations proximately caused Mexico's harm. That satisfies PLACA's predicate exception. First, the complaint details that petitioners deliberately supply the illegal Mexican market by selling guns through the small number of dealers that they know sell a large number of crime guns and who repeatedly sell in bulk to the cartel traffickers. Petitioners' arguments ignore these allegations. Next, as the Court said in Twitter, an aider and abetter is liable for harms that were a foreseeable risk of that violation. That framing, foreseeable risk, is the proximate cause question. As this Court put it in Bank of America, does the harm alleged have a sufficiently close connection to the conduct the statute prohibits? The answer is yes. The laws broken here are designed to keep guns out of criminals' hands. Those violations put guns in criminals' hands, and those criminals harmed Mexico. Petitioners' arguments would rewrite PLACA and proximate cause law far beyond this case. Petitioners argue that independent criminal acts sever the causal chain. But an independent act, criminal or not, only breaks the causal chain if it is not foreseeable. These acts were foreseeable. Petitioners argue that Mexico's injury is not direct, but their directness argument borrows from cases involving indirect victims. Mexico is not an indirect victim. We are here at the beginning of this case. This Court need not vouch for Mexico's allegations, but it must assume they are true. And the issue at this stage is not whether every aspect of Mexico's complaint survives, but whether any of it clears the predicate exception. Mexico should be given a chance to prove its case. I welcome the Court's questions.
How is your suit different from the types of suits that prompted the passage of PLACA?
Our suit is different, Justice Thomas, because the types of suits that prompted the passage of PLACA specifically did not allege that the manufacturers had violated any law. So if you look, for example, at the Third Circuit's decision in City of Philadelphia, the Illinois Supreme Court's decision of City of Chicago, each of them specifically made the point that those manufacturers were not alleged to have violated any federal or state statute. They were being held liable for actions solely caused by criminals. And that's the important balance that this bipartisan act struck. If an action was solely caused by criminals, manufacturers of guns, like any other product, wouldn't be held liable. But
well, it seems as though the only connection or the difference would be the allegation or the assertion that you have an aiding and abetting problem with respect to the manufacturer. You could have done that in the other cases, couldn't you?
I don't know that they could have, and they certainly didn't. And PLACA, for more to the point, could have also barred, as many states did, all lawsuits against manufacturers. Many states barred lawsuits by cities. Many states barred lawsuits by all manufacturers. PLACA didn't. And what PLACA did was to preserve exactly these types of claims. You asked a question about the specific allegations of illegality. I want to direct you to paragraph 249 of the complaint. There is a list at paragraph 249 that includes 18 U.S.C. 922, several different subparts, A6, D1, 923 G1, 924A1A, and those map closely onto the predicate exception we're talking about, including, of course, that first example of the predicate exception, which involves aiding and abetting a straw purchase, which is at the core of what we are talking about. That's 18 U.S.C. 922A6, 922T1, 922M, 924A1A, 923G1A. Each of those are specified in the complaint, and the manufacturers and distributor in this case are alleged to have aided and abetted all of them.
Counsel, I'm sorry.
Just one last. Have any of these violations been violations that ATF has pinpointed?
They have not been violations that ATF has pinpointed, and that's a point that the petitioners are fond of making. I think the issue with ATF, as the complaint alleges, is that ATF, and you can find this at paragraphs 126, 129, 133, ATF, just because of its resources, is only able to look, even every year, at about anywhere between 3 and 10% of licensed dealers and manufacturers and distributors. And if PLACA, again, had wanted ATF to be the sole arbiter of this, it could have barred cases altogether. It could have required a conviction. It could have required the stripping of a license before any of these allegations were allowed to go forward. It didn't do any of those things in the predicate exception.
Counsel, in his argument this morning and also in his brief, Mr. Francisco focused on two particular cases, the Twitter case, of course, and you engaged with that in your brief, but also Hemigroup, and you cite that once in a string cite at page 42 of your brief. I wanted to give you an opportunity to say a little bit more about that.
Certainly. So Hemigroup, of course, pertains to the proximate cause issue. And Hemigroup, I think, is in a line with all of the cases that talk about what my friend Mr. Francisco calls direct harm. And that's something that you heard a lot in his argument. Direct came up a lot. Independent came up 13 times. Direct harm, if you look at Hemigroup, if you look at Associated General Contractors, Holmes, ANZA, Bridge, there is a list of proximate cause cases. And if you look at each of them, what you will find is that the issue there was that the victim who was bringing the complaint was an indirect victim. So this court, like many of us, finds it hard to speak with one voice on proximate cause. One of the few times it has is in Lexmark. And what Lexmark says is the reason for that directness requirement is that there ordinarily is a discontinuity between the injury to the direct victim and the injury to the indirect victim, so that the latter is not surely attributable to the former. That, I think, is an important component of the proximate cause argument, and I want to touch on this independent idea because it came up so much. As I said in the opening, an act that is independent can still be foreseeable. It's when an independent act is unforeseeable that you have the intervening cause that breaks the causal chain. So Mr. Francisco mentioned that 1876 case that Justice Gorsuch did not write about Milwaukee Railroad. That is the case that says the primary cause may be the proximate cause of a disaster, though it may operate through successive instruments, as an article at the end of a chain may be moved by a force applied to the other end. So it's not a question about one step or a causal chain. It's a question about whether something breaks that chain. Hemi was an example of something breaking the chain because you had unlawful contact over here and an injury over there, and the two weren't connected by anything other than a very articulate series of steps. The injury and the conduct were very different.
You know, it's nearly impossible to say that something's not foreseeable in a chain. it doesn't help me when people talk foreseeability. I'm much more helped by the restatement third of torts that basically says you impose liability for harms within the scope of the risks that made the defendant's conduct wrongful in the first place. That makes much more sense because, as I started earlier with Mr. Francisco, we know that a straw seller is going to sell to someone who is going to use the gun illegally, because if they weren't, they wouldn't use the straw purchaser. And that illegal conduct is going to cause harm, and harm like this, that the gun is going to be used in some way to injure people. Correct?
That's correct.
And that basically is much easier than saying that all foreseeable harms are, you're responsible for all foreseeable harms. You're only responsible for those that your wrongful conduct causes a risk about.
That's exactly right, Justice Sotomayor, and that's why I started with that reference to Twitter, because when Twitter talks about the aider and abettor being responsible for harms that are a foreseeable risk of the conduct, that's the closest thing that I've seen that comes to encapsulating what a proximate cause test is. It's foreseeable
now, can I
risk.
go back to what's troubling me? You have the manufacturers aiding and abetting, in your theory, by producing guns that are singularly attractive to the cartel because they're designed in a particular way that cartel members like because they're showy. They're making erasable serial numbers, which obviously are attractive to criminals because every criminal would like to erase the serial number if they can. So that's what you claim is aiding and abetting. But what are you claiming Interstate, the distributor wholesaler, did? Other than selling the product, they don't design it. They didn't do any of the, they didn't design it. They didn't have anything to do with that. They just have a product they're selling. So how do we make, how are your allegations enough with respect to Interstate? And if we were to say they're not enough with respect to Interstate, doesn't that break the causal connection with the manufacturers?
Justice Sotomayor, the complaint actually details 6 or 7 different examples of how the manufacturers are actively participating in the illegal market.
I'm
One of them is
accepting that.
design. Yes, yes.
I'm asking, tell me what it says that the distributors are doing.
What it says the distributors are doing, including the one that's named in this complaint, are knowingly supplying the dealers who we know sell unlawfully across the border.
But knowledge is not enough. We have repeatedly said mere knowledge is not enough. You have to aid and abet in some way. You have to intend and take affirmative action to encourage what they're, not to encourage, but to participate in what they're doing.
What this court said in Rosemond is a person who actively participates in a criminal scheme, knowing its intent and character, intends that scheme's commission. That's the criminal aiding and abetting standard.
Yeah, that is the standard. That was a question I wanted to circle back with you on, Ms. Stetson. And that, if 922 and 3 and 4 are your predicate violations, and aiding and abetting under 18 U.S.C. Section 2, I think, would then be your aiding and abetting hook. Those are criminal statutes, and the mens rea under Rosemond is intent, right?
The mens rea under Rosemond for aiding and abetting in the criminal context would be intent.
And you're invoking criminal statutes, so is that the standard you have to meet here?
It's the standard we have to meet, but just as in Rosemond, if you actively participate knowing the scheme,
sure, then you can infer
then
knowledge.
you can infer intent,
I get
particularly
that.
at the motion to dismiss stage.
Yeah, got it.
And let me, if I could, I want to be pretty specific about some of the allegations in the complaint, because what I heard this morning was that the allegations authorities have repeatedly identified and recovered defendants' guns in connection with notorious gun trafficking rings. Paragraph 232, defendants are aware that specific networks of distributors and dealers they were supplying were consistently channeling their guns. Paragraph 233, Century Arms received communications from ATF. Those trace requests revealed that specific distributor and dealer networks were disproportionately associated with those guns. Paragraph 234, all of the other defendants have access to the same information. That is exactly the kind of specific allegation in the complaint at this stage that satisfies a motion to dismiss.
But those statements aren't allegations of violations of the law, correct? I mean, those statements just go to whether or not the defendant had knowledge that at the end of the day, some dealers might be doing something wrong. These guns that they're selling are ending up in the wrong hands. But I took the statutory language here to be requiring more in terms of violation on the part of the defendants in this case.
It certainly requires, Justice Jackson, a knowing violation. But as far as these allegations go, what these allegations show is that the dealers, a small number that is responsible for the large number of guns, are knowingly violating federal laws, and that these suppliers, these manufacturers and the distributor, know that is happening and continue to actively supply. And I want to make—
What you don't have is particular dealers, right? I mean, it's a pretty, there are lots of dealers, and you're just saying they know that some of them do. But which some of them? I mean, who are they aiding and abetting in this complaint?
There are a number of dealers that we do know are responsible for selling a great number of crime guns into Mexico. There's the Washington Post article that the complaint mentions. That names 8 or 10 different dealers by name, most of which are still very actively in the business. And more to the point, again, we are here at a motion to dismiss. What we have alleged is that these manufacturers know from ATF exactly what dealers are the problem, are the rogue dealers. So the hypothetical that you gave Mr. Francisco, Justice Kagan, is not a hypothetical. That is actually this case. The allegations in this case establish, for purposes of getting past the motion to dismiss on the predicate exception, as Justice Jackson mentioned, that there are allegations of aiding and abetting violations of federal laws. And I want to get back to a question that Justice Barrett asked as well about what the violation is, because I think there's been some noise in the data.
Ms. Stetson, before you do that, could I just ask you something related to the point you were just discussing? Are there any allegations in the complaint that the petitioners knowingly sell to specific red flag dealers?
Yes. If you look at paragraph 247, and I'll read it because I think this one is important. Defendants supply dealers with all the guns they can pay for, without any public safety conditions, even if a gun dealer has been repeatedly found to have violated gun laws, been indicted, its employees have had federal gun licenses revoked, or has repeatedly supplied cartels in suspicious and obvious sales to traffickers, including repeated bulk sales. That is an allegation that goes directly to specific rogue dealers. And that gets us, I think, to the Twitter direct sales dichotomy. What Mr. Francisco says is that Twitter was very actively managing something. Twitter was actively managing, to the extent it was managing anything at all, its algorithm. And what this court said in Twitter was that that kind of starting the platform, sending it out into the world, and standing back and watching, which was the phrase in Twitter, is not enough. What you need is active, culpable participation. The active, culpable participation here is continuing to sell guns to rogue dealers that you know are the problem dealers.
You
that is
haven't
exactly direct
identified the
sales.
dealers. Justice Alito was asking you about specific red flag dealers, but that paragraph doesn't identify dealers, and it seems to me that that's one of the distinctions between this case and direct sales, and for that matter, this case in Twitter. Let's talk about Twitter. There was a specific rogue actor, ISIS, and there was a specific attack in France. And so the attempt was to draw the line between them, and we said it wasn't enough. In direct sales, there was a specific manufacturer, pharmaceutical company selling to a specific doctor, causing specific harm. And Justice Alito asked you what specific red flag dealers there are. You haven't sued any of the retailers that were the most proximate cause of the harm. You haven't identified them that I can tell in the complaint.
Justice Barrett, there are many, many paragraphs that specifically identify rogue dealers in the complaint. If you look at approximately paragraphs 147 to 203, they identify specific dealers that have been found to have sold guns in bulk to traffickers that go across the border. If the question is, you haven't named in paragraph 247, which says that these manufacturers know that they're selling to dealers who sell to cartels, I think that is pushing a little bit past what is necessary for drawing reasonable inferences from a motion to dismiss. But I want to pause too on Twitter and direct sales. Direct sales involved an entity that was selling large quantities of morphine to a doctor. The entity was licensed, the doctor was licensed. And if you look at direct sales, what direct sales says is that the quantities that were at issue were in line with that defendant's marketing practices. There was nothing unusual about the quantities at issue there. What was unusual in that case, and what is different in that case, is that the direct sales manufacturer did not know that that specific doctor was a problem. It had been put on notice that there were other doctors who were selling lots of their products to people who shouldn't be getting them. But unlike this case, where these manufacturers and the distributor are alleged to know who the dealers are and what problems they are causing, the manufacturer that was held liable for criminal conspiracy in direct sales didn't know anything about that doctor. All it knew was that the doctor kept sending them legal order forms, and they kept fulfilling the orders. That was direct sales. This case is much like direct sales, if not stronger, for that reason.
What do you do with the suggestion on the other side and in the amicus briefs that your theory of aiding and abetting liability would have destructive effects on the American economy, in the sense that, as you've read in the briefs, lots of sellers and manufacturers of ordinary products know that they're going to be misused by some subset of people. They know that to a certainty, that it's going to be pharmaceuticals, cars, what you can name, lots of products. So that's a real concern, I think, for me, about accepting your theory of aiding and abetting liability. And relatedly, you've referred often to the motion to dismiss, of course, as you're well aware. Getting past that is often the whole thing. So I don't think we can just rely on the motion to dismiss. But the broader point, be interested in your reactions, how we rule for you, but don't cause that problem that is identified with great force in the briefs.
Sure. So let's take Budweiser as an example. As you heard Mr. Francisco say today, if Budweiser had was alleged to have a practice of selling bulk quantities of Bud Light to liquor stores that were arranged next to high schools, and it was selling more and more into those high schools, knowing that those liquor stores were regularly serving underage students. And in fact, the Bud Light designed to put out a new can that says "Best Prom Ever," and sold it right into that high school. That is the allegations in this case. If you have a product manufacturer of a dangerous product that is alleged to have done all of the things knowing who they're selling to and what is being done with that product, then and only then, I think that product manufacturer has a problem. If you look at the examples that are given in PLACA that aren't at issue in this case, the examples that the congressmen and senators were concerned about in PLACA were when a car dealer sells a car to someone who later drives drunk, when Campbell's is sued because someone is killed with a soup can. Those are the things that PLACA was concerned about. This case marches through in detail allegations taken as true at this stage that these manufacturers know that they are selling a dangerous product to specific rogue dealers who are selling to straw purchasers for the cartels across the
What if a beer, I'm sorry, I cut off your sentence. Did you? What if a beer manufacturer knows that the per capita beer sales in a small college town are, 50 times more than another town without a college there? Is that enough?
I don't think that alone would be enough. I mean, you do have allegations in this complaint that the number of dealers that have arranged themselves along the border of Texas and Arizona of Mexico are vast. I don't think that itself would be enough. It would be, you know, the dealers are there, you know what they're selling, you know who the bad apple dealers are, because we're not talking about every dealer in the country. We are talking about a small percentage of retailers responsible for about 90% of the crime guns that are found. Those retailers in that college town, if you plug in that hypothetical of Budweiser, and Budweiser was marketing in with some kind of, you know, best first-year homecoming ever, then you would again have the problem. But you'd have to have each of those specific allegations in the complaint that you have here.
Ms. Stetson, I guess what I'm concerned about, you talked in response to Justice Kavanaugh about what PLACA was about, what it was getting at, and I really thought, as the statute itself says, that it partially, at least, is about Congress protecting its own prerogative to be the one to regulate this industry. That there were concerns, and the statute itself says that, you know, we're worried that tort suits are an attempt to use the judicial branch to circumvent the legislative branch of government. And to me, when you think about that as being the reason why Congress wanted to have immunity in this area, and I'm starting from the, I'm sure, consensus view that we're trying to do what the statute, the statute wants. I think when you think about that, the predicate exception makes perfect sense to the extent that there's a violation of a state or federal statute at issue. Because Congress says we want to be the ones to regulate, but in this particular situation in which a tort suit aligns with a clear violation of the law, then we don't worry that we have judges and the common law system dictating what people can do. I worry that without that clarity, in a complaint like yours, where we don't really see exactly how the manufacturers are violating a particular state or federal law, that we're running up against the very concerns that motivated this statute to begin with. So can you speak to that?
Sure. Justice Jackson, I think if you look at the paragraphs, let's call it 203 to 250 of the complaint, which pertain exactly to the violations of federal law that we started with, all of the specific statutory violations, 922 subparts, 923, 924, what you will find is that there are plentiful allegations that these manufacturers, by knowingly selling to the rogue dealers that they know are selling to straw purchasers, are aiding and abetting that violation. Part of the problem
Well, I
maybe we're
understand,
having—
but I guess my point is that Congress didn't want like general aiding and abetting concerns to be what is imposing duties on these manufacturers. I mean, if you look at your lawsuit and what you're asking for changes to the firearm industry safety practices. You say not, putting these kinds of constraints is a thing that should give rise to liability. The distribution practices, the marketing, all of the things that you ask for in this lawsuit would amount to different kinds of regulatory constraints that I'm thinking Congress didn't want the courts to be the ones to impose.
So let me answer the aiding and abetting liability point first, and then I want to answer your remedies point, because I think that's particularly important. Aiding and abetting, of course, was specifically contemplated in PLACA in the first predicate exception itself. Any case in which the manufacturer or seller knowingly made a false entry, et cetera, or aided, abetted, or conspired with any person in making any false or fictitious statement. Aiding and abetting is baked into this.
So you don't read that to be very, very closely tied to the record-keeping violation or the particular statutory violation that's also mentioned?
No, I mean, that the predicate exception begins by talking about the action in which the manufacturer knowingly violated, and the violation was a proximate cause, including the exceptions that are mentioned. So aiding and abetting these violations of federal and state statutes pertaining to guns is exactly what this exception was built to do. That is why it was carved out in this bipartisan legislation. But on your remedies question, one of the difficulties I think for all of us is that we're here so early. This is a complaint that has asked for a number of different remedies, including a number of different types of injunctive relief. And one of the things that you heard the petitioners and a lot of their amici in their briefs complain about is what these remedies might do. That is for the district judge on remand to make sure that the judge equitably crafts a remedy that is designed to limit the harm to Mexico. Mexico is not trying to legislate gun use in the United States.
Yeah, I understand that. I guess I'm just wondering whether the PLCA statute itself is telling us that we don't want the courts to be the ones to be crafting remedies that amount to regulation on this industry. That was really the point of the entire thing. And so to the extent that we're now reading an exception to allow the very thing that the statute seems to preclude, I'm concerned about that.
Justice Jackson, if PLCA had wanted to preclude any lawsuit against a manufacturer, including for instances where the manufacturer had committed a wrong, it could have done that, as so many different states, in fact, did. What PLCA did in this effort, which, as I mentioned, was joined by members of both parties, was to carefully carve out circumstances where the manufacturer or the seller was alleged to have done something wrong. The thing they were concerned about was lawful design and manufacture and sale of product and injury solely caused by others. That is replete throughout the purpose section of PLCA. PLCA could have been designed quite differently. It was designed this way for a reason, so that harmful actions by manufacturers and sellers breaking the law could continue to be remedied. That was exactly the point.
You've mentioned about 4 times that it was bipartisan. What's the relevance of that to our interpretation?
I think yes, I haven't gotten to 13 times yet, but 4 will do. The fact that it's bipartisan, I think, points out, particularly in this climate, that what was being challenged there were really unusual lawsuits that really weren't showing up in any other part of the economy against the manufacturers of a lawful product, selling their product lawfully, distributing their product lawfully, where no allegations were made in those prior lawsuits about unlawful behavior. That was what PLCA carefully carved out. What it left, among other things, were actions for things like negligent entrustment, product liability. And product liability is interesting, by the way, because you probably notice this as well. Product liability specifically says you can sue for product liability, but if it was a criminal act, then that act becomes the sole proximate cause. That, of course, is very different from the violation of which is a proximate cause, which is what you see in the predicate exception. I think that language difference is very important.
Thank you, counsel. I'd like to ask you pretty much the flip side of the question I asked your friend on the other side, which you allege that 2% of the guns manufactured in the United States make their way to Mexico. I assume the volume of that is critical to your argument. I just want to know how much is enough. If it's 1% or a more minuscule amount, where's the floor?
So 2% is always a question that begs the question of what? And here, what you have is data in the complaint that says, this is paragraph 438, between 342,000 and 597,000 of defendants' guns. And remember, this is not the entire industry we're here talking about. So up to 600,000 of defendants' guns are likely trafficked into Mexico every year. That's your 2%. But I think the issue is not so much whether it's 2 or 10 or 70. It's, do these manufacturers know who the rogue dealers are and what they're doing? And this complaint, in all of those paragraphs that I read to you earlier and many others around them, specifically says these manufacturers know the trace data that show the dealers, that show the bulk sales that are being made to traffickers who come in repeatedly over a short period of time and bring the guns into Mexico where they're found at crime scenes. That, I think, more than percentage is important.
You emphasize you have a number of criteria or examples. You know, the gun says this, or it looks like a military weapon and it has an American flag. And, you know, Zapata's quote about better to die on your feet than live on your knees. I mean, those are all things that are not illegal in any way. And the idea, I mean, there's some people who want the experience of shooting a particular type of gun because they find it more enjoyable than using a BB gun. And I just wonder exactly what the defendant, the manufacturer, is supposed to do in that situation. You say, no, he shouldn't be marketing a particular legal firearm because they're going to go into Mexico at a higher percentage than others?
Mr. Chief Justice, I think it's not so much that the defendants are designing a particular gun. It's that what the complaint alleges is that they are designing certain guns to target the Mexican market, including the cartels. So if you take the example that you gave, this is paragraph 215, Colt produces 3 models of guns that it specifically targets to the Mexican market: the Super El Jefe, the Super El Grito, and the Emiliano Zapata 1911. These are coveted by the cartels, and you can see evidence of this as paragraphs 217, 218, 219, 220, and they are smuggled into Mexico in volume, which you can also find in the...
Do you know what the percentage of those guns that are sold in the United States compared to the ones that are found in Mexico is?
I don't know, but again, the percentage I think is less important than the allegation that they are smuggled into Mexico in volume and coveted by the cartels, including being found on the person of many cartel chiefs who have been arrested.
Thank you. Justice Thomas?
If there's no earlier finding of a violation, how is that done within the context of a civil suit like this?
If there's no earlier finding of a violation, because of course, as I think you're getting at, the predicate exception doesn't require one. There's another exception that does. I think what you would find are that at the motion to dismiss stage, the question is simply, has there been a sufficient allegation of aiding and abetting in order to get you past the predicate exception? Now, we talked about how we are here early. There are actually still other motions to dismiss to be addressed.
But it has to be aiding and abetting of something.
Aiding and abetting the violations, including of straw purchasing.
So it is the violation that you say in your complaint there is a violation, but there's been no finding of a violation. How do we know there is a violation?
I think what the district court would determine at summary judgment, if the evidence comes back and says, for example, these manufacturers simply had no idea what their distributors were doing or who their guns were going to, or these dealers were doing everything by the book and they are not responsible for the straw purchases that kept coming into their stores. If you had that evidence, then on summary judgment, as has happened before, the court would say, we can't find the predicate exception met here.
So let's say I am the alleged straw purchaser or the retailer who sells to a straw purchaser. Now you have found that I have violated the Gun Control Act, right? And my point is, how do you make that finding within the context of this suit?
Justice Thomas, within the context of that suit, I think you would take discovery from the dealer and ask the question, because remember the predicate exception goes to knowing violation. Ask the dealer what it knew when it sold, for example, as has been alleged in the complaint, dozens of guns over a 2-month period to the same person. The evidence at summary judgment will flush out some of these questions. But
so you're saying you can find a violation of selling to a straw purchaser within the context of a civil suit against the wholesalers and the manufacturers?
I think maybe where you and I are parting is on the issue of finding a violation. Yeah. We've alleged those violations specifically in the complaint. As far as finding the violation, I think what the district court would do on remand after discovery, if provided we get past the other motions to dismiss that are pending, after discovery would be to ask the question, has the evidence pointed to actual violations? So if you take the Arcadia, California case, that was a case in which at the summary judgment stage, some defendants were dismissed because there was not evidence that they were acting unlawfully. Others were kept in because there was evidence that they were acting unlawfully. So that might be the best example of the dichotomy you're talking about.
Wouldn't you run into, at some point, a due process problem as far as the people you allege to have violated the Gun Control Act? who have not been charged with that by ATF and proven to have done that by the government?
No, I don't think you run into a due process problem, precisely for the reason I think you pointed out a couple minutes ago, Justice Thomas. There's no requirement of a conviction, and there are plenty of examples, including Williams versus B. Miller from New York, of instances where manufacturers have been alleged to have to have aided and abetted a violation by a dealer, and that case has been allowed to go forward. There's not a due process issue that inheres in that.
Justice Alito?
There are some very interesting technical legal issues in this case. Proximate cause, aiding and abetting, how much do you have to plead in a complaint? And you and Mr. Francisco have briefed and argued those very well. It's very helpful to the court. I just thought I would ask you a question that may be on the minds of ordinary Americans who hear this argument or learn about the case. Mexico says that U.S. gun manufacturers are contributing to illegal conduct in Mexico. There are Americans who think that Mexican government officials are contributing to a lot of illegal conduct here. So suppose that one of the 50 states sued the government of Mexico for aiding and abetting illegal conduct within the state's borders that causes the state to incur law enforcement costs, public welfare costs, other costs. Would your client be willing to litigate that case in the courts of the United States?
Justice Alito, I think we would have to accessorize that hypothetical with what I assume are a lot of the things that are built into it, that there are no forum and venue questions, and that the kinds of allegations are specific and talk about specific harms to the state. So
well, would your government say, whoa, your client say, whoa, sovereign immunity, you can't sue us on this?
Well,
would you be willing to litigate all the doctrines that would apply if the government of Mexico were not entitled to sovereign immunity?
So, Justice Alito, under FISA, of course, Mexico is entitled to come in, and the petitioner's own amici point this out, to come into this case just like any other litigant. There are, of course, differences if Mexico is brought in as a defendant. So I can't and certainly don't feel comfortable giving away things like sovereign immunity on behalf of the government of Mexico.
Well, I understand that. So the argument basically is it's a one-way street.
No, Justice
Alito,
Alito,
Mexico can sue U.S. manufacturers here for harm caused in Mexico, but one of the states here can't sue the government of Mexico for harm caused in the United States.
I don't think it's entirely accurate to call it a one-way street, and if the street is one way, it's because Pfizer and other decisions from this court have said that when a sovereign comes into this court as a plaintiff, it is treated exactly like any other plaintiff, no more and no less.
Thank you.
Thank you.
Justice Sotomayor? Justice Kagan? Justice Kavanaugh?
Just want to pick up briefly on questions Justice Thomas was asking. I mean, would your theory of aiding and abetting suggest that manufacturers should be concerned if their products, their lawful products, are sold in certain communities or certain neighborhoods where they're more likely to be misused? You know, we manufacture knives, but there are a lot of stabbings in certain neighborhoods. We should make sure our products aren't sold there, or a sporting goods company and baseball bats are used to, you know, storm CVS's or what have you. So we shouldn't sell in this city, or prescription drugs are misused in a certain area. So we need to be alert and make sure. Is that where your theory of aiding and abetting leads, that you have to be kind of tracing everything down the chain and make sure we're not selling in these places, or it's not ending up in the places where it's more likely to be misused, or a certain percentage, to go to the Chief Justice's point, are being misused?
Justice Kavanaugh, I think what you've described would qualify under Twitter as general awareness. It would not qualify as specific culpable participation. If you had a manufacturer...
You make baseball bats, and you know they're being used in a particular way in particular areas by particular gangs. And you should, so therefore, yeah, we got to make sure that we're not selling to those sporting goods stores that are in particular neighborhoods.
I think that the first lawyerly response is that guns and drugs tend to be treated differently than things like knives and baseball bats. But even that aside, if you knew that your baseball bats prescription drugs were being sold into a particular pharmacy, and this has happened, of course, in the opioid cases, were being sold into a particular pharmacy at, in a small town at numbers that were simply insustainable, and you knew that you were continuing to sell after being told by the federal government that you were selling into a rogue dealer, and you continued to sell into that dealer, then yes, you would have a problem.
Thank you.
Justice Barrett. Justice Jackson?
But do you concede that you would have a problem or not, depending upon how the statute is worded? I mean, we're in a statutory scheme here. We're not just doing aiding and abetting liability as a matter of common law. Don't you agree?
I do agree with that, Justice Jackson, but I think the fact that we're in a statutory scheme is an important element of centering this case where it is now. That's why I said earlier we are at the beginning of this case.
I understand. I guess I just quickly in response to what Justice Kavanaugh was just exploring with you, the facts that he laid out seem to me to be covered by this particular PLCA immunity. That Congress looked at that situation and said, the term qualified civil liability action, which you can't bring in court, means a civil action resulting from the criminal or unlawful misuse of a qualified product by the person of a third party. So in other words, Congress started with Justice Kavanaugh's example. My product is being used by third parties in criminal ways, and they said immunity. So to read the exception to that as essentially capturing the same facts, if you know that your product is going to these people, seems odd to me.
Justice Jackson, what Congress said was immunity unless. And the predicate exception that we've been talking about says immunity unless the manufacturer is alleged, among other things, to have aided and abetted violations of federal gun laws.
Thank you.
That's the important point.
Thank you, counsel.
Thank you.
Rebuttal, Mr. Francesco.
Thank you, Mr. Chief Justice. Just a few points. First, Justice Thomas, as to one of your questions, if they're right under PLCA, this would in fact revive the exact same lawsuits that PLCA was meant to prohibit. If you look at Mexico's complaint, the underlying torts alleged, which is what they're seeking relief on, are the exact same torts that were at issue in all of the other cases. The violations only come in their effort to get around PLCA and fit with one of its exceptions. But if you accept their interpretation of the PLCA exception, you will have revived exactly the same type of lawsuit that PLCA was meant to prohibit when they adopted the statute in the first place. Secondly, my friend talked about some paragraphs in their complaint, but I think that their complaint makes quite clear what their basic aiding and abetting theory is. Paragraph 228, and this is an allegation that they repeat throughout. Each defendant's policy is to sell its guns to any and all federal firearms licensees. That is anyone that the federal government says that we can sell to. So their allegation is that we're treating all retailers exactly the same. We're not treating any one better than any other. We're treating them the same. That's important because in Twitter, the court made quite clear that the reason they didn't get across the aiding and abetting line was because there was no allegation that they were treating ISIS, who they knew to a metaphysical certainty was on their platform. They weren't treating ISIS any better or worse than any other customer. Instead, they go on, and this is paragraph 110, to explain their theory. A manufacturer of a dangerous product is an accessory or co-conspirator to illicit conduct by downstream actors where it continues to supply, support, or assist the downstream parties and has knowledge, actual or constructive, of the illicit conduct. I think that's the mere knowledge theory that my friend was just referring to, Justice Kavanaugh. That, however, is the theory that the court squarely rejected in the Twitter case. Turning to foreseeability, Mr. Chief Justice, there was an exchange with my friend on the case law where I think what I heard her say was that an intervening independent act didn't break the chain if it was foreseeable. Well, I would say that that is completely inconsistent with this court's repeated statement that foreseeability alone isn't the standard. It's also completely independent with the Hemi Group case that did not involve a derivative injury. New York City was the only plaintiff that could sue for the lost taxes that New York City suffered. There was absolutely no other plaintiff that would have been able to pursue that remedy and that loss. Yet this court held that the intervening independent act did break the chain. Lexmark is no different. It did not involve an intervening independent act. If I trick consumers into not buying my competitor's products, I've directly harmed my competitor. There is no intervening independent act. As to the various treaties, I would agree, Justice Sotomayor, with your suggestion that the law and the verbal formulations here are kind of a mess. But if you actually look at the cases that the treatises cite for their assertion that foreseeability alone is the standard, they don't cite this court's cases, which is kind of surprising if what they're supposed to be doing is describing the law rather than making the law. But the cases that they do cite principally involve special relationships, like a landlord-tenant relationship or a teacher-student relationship. They don't cite any case in which a manufacturer has been held liable because some criminal unlawfully misuses its product to harm somebody else. My friend again emphasized the Washington Post article. I would urge you to read that article from beginning to end. I think it's very helpful in illuminating how even their theory of mere knowledge doesn't make sense. My friend also talked about 3 pistols sold by Colt with Spanish-named firearms. The notion that selling a Spanish-named firearm is what gives rise to joint purpose with cartels under the aiding and abetting statute is as wrong as it is offensive. There are, after all, millions of perfectly law-abiding Spanish-speaking Americans in this country that find those firearms very attractive, and making those firearms available cannot possibly cross the line into aiding and abetting liability. But even if it could, the notion that selling 3 Spanish-named pistols is the proximate cause of cartel violence in Mexico is frankly absurd, and I don't think it comes even close to establishing Twombly's plausibility standard. My final point is just to step back and talk about what PLACA was really about. At the end of the day, PLACA is about protecting Second Amendment rights. It's not just about protecting the manufacturers, the distributors, and the retailers, but it's protecting the right of every American to exercise their right under the Second Amendment to possess and bear firearms. That right is meaningless if there are no manufacturers, retailers, and distributors that provide them in the first place. We ask that you reverse.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
All right. Well, that was actually pretty short and sweet, I feel like, for Supreme Court cases that we have listened into. It's always really interesting to hear the discussion between the attorneys, when they are discussing these cases, and for us advocates and us survivors, sometimes it's hard not to scream out, like, "Wait a minute!" But I definitely want to begin our conversation and transition into that. Thank you to everyone who has been engaging in the chat. Please feel free to continue to engage there, but definitely if there are pressing questions that you would like for us to answer, definitely put those into the Q&A. That way we also have the ability, as our panelists are giving their are continuing to give their analysis of what we've heard today, we can definitely get to those as well. So next I'm going to bring up Bella, who is the grassroots organizer for Stop U.S. Arms to Mexico, to introduce our panelists, reintroduce our panelists, excuse me, to give their takeaways.
Thank you, Christina, and thank you everyone for joining. Again, one more time, I'm going to put in the chat some instructions for interpretation if you're just now joining. So you can hit the bottom globe at the bottom of your screen and select the correct language. Hello, everyone. Again, my name is Bella. Like Christina said, I'm the grassroots organizer with Stop U.S. Arms to Mexico. I want to thank all of the wonderful experts and panelists and attorneys that we have on the call today. And thank everyone for joining and spending this morning with us. We're going to jump in by listening to 3 major takeaways from each of our attorneys, as well as Ryan. And I'll read their bios very quickly, and then afterwards we'll come back, ask everyone for their main call to action after hearing this case, and then we will dive into a Q&A. So without further ado, I would like to introduce Amanda Berman. Amanda Berman is leader in Crowell's appellate practice and submitted a brief on behalf of scholars in this case in support of Mexico. Amanda, please take it away.
Sure, thanks, Bella. So that argument actually went a little longer than it was set to. So there was definitely some interest from the full court. What I think we heard is that I'll call them the liberal wing of the court, Sotomayor, Kagan, Jackson, were much more interested in the facts. And they do seem more willing to entertain the possibility that some set of facts along these lines would fall within the predicate exception to PLACA. That said, Jackson in particular did ask some hard questions about whether required more was alleged here more than it required more than knowledge. And Kagan seemed to be asking, and Alito joined her at one point on this, of course, whether there were specific dealers alleged to be acting unlawfully here. So I think it does show that even they have some skepticism about whether these particular allegations in the current version of the complaint are enough to get you within that exception to PLACA, which is the tough question here. The more conservative wing of the court until the very end was very focused on, what is the underlying legal violation here? Is it just aiding and abetting under PLACA, or what other statute, criminal or civil, is at issue here? But that said, I will say that Gorsuch and Barrett did ask some questions that at least seem to be open to the idea that an aiding and abetting violation could be alleged under PLACA under some set of facts. If I had to predict, I think this case is unfortunately either going to do one of two things, which is one, break down on, frankly, party lines, or two, I'm a little worried that the progressive justices will join a narrow opinion saying that these specific allegations are just not enough to get within the PLACA exception, including because, for example, there's no specific dealer that's named as making unlawful sales, or it's not entirely clear how manufacturers are violating a particular state or federal law, as Jackson seemed to be driving at a couple of times, which is not the outcomes we want, of course, but that is where I predict this is likely going.
Thank you, Amanda. Next, we will hear from David Pacino. David Pacino is a legal director and deputy chief counsel at Giffords Law Center to prevent gun violence. David pursues affirmative litigation and defends laws that enhance firearms safety. He also drafts and analyzes gun legislation and works to promote federal, state, and local policies designed to prevent gun violence. David, please take it away.
Thanks very much, Bella. I'm great to be here with you all. I think first of all, I think Amanda's spot on in all of her analysis and the unfortunate implications from it. I think it's hard to count to 5 votes that would rule with Mexico here. But I think that it is also important to note the ways in which it seems like you could get to that majority, which is to say that I don't think we saw what could have been the worst case oral argument here. I think there was a lot of space for a potential future lawsuit, and actually concurrent lawsuits, because the Mexican government has a lawsuit that is against a specific dealer and is about specific dealer allegations. That's the Diamondback case in Arizona. The big structural thing I think here, and this came out expressly sometimes and implicitly some other times, was comparing this lawsuit against the lawsuits that were brought before the federal immunity statute, PLACA or PLICA, was enacted. And that came through in some ways about how the complaint looks different. And one of those items was about the naming of specific dealers. Counsel for Mexico, Kate Stetson, was highlighting the ways in which there were specific statutory violations that were alleged. And the follow-on question there is, well, could you just tack on those statutory violations to one of those pre-PLACA lawsuits? And I think that is really going to be a lot where a lot of the action is here. I think Justice Jackson's questions kind of feed it into that question as well. She kept returning to the question about whether aiding and abetting was a common law or a generally applicable question, or whether we were specifically talking about PLACA's aiding and abetting. And I'm speculating here, but I wonder if the reason for that was an effort to try to cabin ruling on aiding and abetting to specifically PLACA and not to have it more generally apply to plaintiffs in a going forward basis. But that's speculation on my part. I think lastly, the focus, as Amanda noted, on the specific allegations in the complaint, the specific misconduct as to the distributors and to the manufacturers, suggests some skepticism with the sufficiency of the allegations. And I think that that Mexico's counsel noted that and emphasized in her argument that several times that we are at the motion to dismiss stage. So we haven't gotten to the point where this is a fact finding. Mexico should have the chance to be able to do that process, to go through discovery, to make its case. I think she argued that point well, but I think it probably does point to a perceived vulnerability in Mexico's case here. So for all of those reasons, I think one has to be pessimistic about the outcome for Mexico in this specific case. But I do think that there are helpful signs for other avenues for accountability, including by the Mexican government.
Thank you, David. Next, we'll turn to Paul Friedman. Paul Friedman is a graduate of New York Law School. He lost a great aunt to Ebola in 1981. From 2016 to 2018, Paul served as the executive director of a nonprofit that emerged from the Virginia Tech tragedy. In 2019, he founded the gun tragedy prevention nonprofit Safer Country, safercountry.org, which is based in Alexandria, Virginia. Paul, please take it away.
First, let me say I'm honored to be on the panel. Amanda, David, you guys are outstanding attorneys and are far more knowledgeable about the development of this case than I. Listening to the hearing, it struck me first, I want to say that with regard to the issue that I think a lot of people were interested in there at the end about baseball bats and why that was coming up, it seemed like Justice Jackson was really trying to get Attorney Stetson to respond in a way that would address a problem that they may have been describing inside the court behind the scenes. That she wasn't feeling was addressed thoroughly enough, and perhaps in the briefs it wasn't getting through. So I think she wanted to pull that out of her. At the end, she asked about the statute very strongly, and the response was, yes, there's immunity, but it's immunity unless. And that was something that Justice Jackson immediately jumped on and said, exactly. Now, when I heard that, as someone who's won a moot court in an oral argument, I get excited because that says to me, I've finally answered the question the way she was looking for me to answer the question. And so that's a good sign, at least for her. And of course, she's already on our team, but I think she was, there's a subtle point there she was probably trying to make that wasn't as apparent to the rest of us. Now, with regard to Justice Thomas, he got tied up for quite a while there asking questions that maybe a trial judge would be aware of, but I don't think he's ever been a trial judge, so I don't think he was really aware of those things. And he was being taken through by Attorney Stetson 101 in a trial judge experience, and due process, et cetera. These subjects were irrelevant and will be disregarded by the rest of the court. Alito, he was bereft of ideas at the end, and I think he was going for this political agenda. You know, he said, I don't want to talk about the law anymore. Let's talk about politics, which is sort of funny because Alito has spent a lot of time saying we're not a political court. But here he brings it up purposely to try to distract the issues. So, and as I said at the beginning, aiding and abetting was going to be a big turning point, but it was interesting that they spent a lot of time on foreseeability. And I think if they were to find a way to deny this on the basis of that, I think they would be upsetting sort of many other kinds of cases that we have long relied upon in the legal system that rely on foreseeability. And I don't think that's going to be where this case turns. So is it going to go in our direction? Certainly politically, it's unlikely. I'm sure there are going to be 5 justices at least who are going to be looking for a way to turn that aiding and abetting issue against the Mexican government. But I think I got to give Attorney Stetson kudos because she did parry every thrust I thought was made against her brilliantly, very maturely, quietly, effectively. never got upset, never got rattled. She really understood her case inside out, and it wasn't lost on her. So if it's going to be lost, it's going to be lost because they're going to do something intentionally, but it certainly wasn't based on what she did. Outstanding work by her.
Thank you, Paul. Finally, I want to turn to Ryan Bussey. Ryan is a former firearms executive who helped build one of the world's most iconic gun companies and was nominated multiple times by industry colleagues for the prestigious Shooting Industry Person of the Year award. In 2021, he published Gunfight, his highly acclaimed memoir about his life in the gun industry. Ryan is a national leader in the fight against radicalization. He is a champion of democracy and was the 2024 Democratic nominee for governor in his home state of Montana. Ryan, we would love to hear any of your takeaways as well.
So I apologize for not being on camera. I'm running around. I had to get up. The argument went just a bit long, but I just want to say I was heartened with the degree of factual competence in the case. I didn't hear, Kagan, I think, was talking a lot about how the distribution system in the firearms industry works. And for everybody listening, they seem to understand it quite well. I didn't hear, I didn't hear real factual errors in there. I as somebody who I mentioned this leading into the case, somebody who is a firearms owner and who wants to preserve responsible gun ownership and who does a lot of shooting and hunting and all that sort of stuff, believes in self-defense with my guns. I'm heartened that I think I heard from even some of the conservative justices a sort of disdain or distaste or troubling sort of murmuring about irresponsible activities that they sort of understand are going on. Have lots of talented attorneys on here that are speaking to the legalities, but I kind of took away from the case like, yeah, well, maybe we're not going to fix it here, but some of the stuff that's going on ain't okay. I get it that that's not, that probably not the legal outcome that some wanted, but I sort of take some solace from at least their admission of that.
Thank you, Ryan. And before we jump into calls to action, I want to give the opportunity for anyone to respond to anything other panelists have said, but also to talk about any next steps for the courts.
I had a question for Ryan. Ryan, really appreciate your kind of assessment of the factual discussion about the way that the industry is structured and how the distribution channels work. I wondered if you could just speak briefly to what I think is a really key point that was made about the relationship between manufacturers and dealers. The counsel for Smith & Wesson, Noel Francisco, had said there is no direct, or he seemed to suggest even indirect relationship between the manufacturers and the dealers. And so I wonder if you could speak a little bit about what it looks like on the ground and what kind of control manufacturers have over dealers and to what extent they know what's going on in dealers.
Yeah, that's a good question, David, one which you and I have hashed about a few times. Generally speaking, the majority of firearms in the country are sold through the process you heard described in the case today. A manufacturer makes them, what we call a two-step distributor purchases them, or is more accurately sold them by the manufacturer. There's usually a very tight relationship there. And then those distributors hold that product at warehouses across the country, and dealers across the country then purchase those products from those distributors. Is it technically correct that there is like a break between each one of those processes in the sales system? Yes, that is technically correct. By the way, the dealer then legally sells it, as long as everything's legal, sells the product to a consumer that walks into a store. So if you want to purchase a product in one of those stores, one of those that was made by Smith & Wesson and then sold to the distributor and then sold to the dealer, you walk in, you complete what's called a 4473. It's a BATF background check form. That's legal as long as you're not an axe murderer. You then walk out with a gun. So there is a legal bifurcation in every single one of those processes. And I think you heard some of the attorneys and justices hashing some of that out today. The part that is not stated properly is the degree to which the manufacturer claims they know nothing about the product once it leaves their door. And I think this is what David is getting at. I'll use Smith & Wesson as an example because they're in this case. they don't sell generally directly to the dealer, although they do sell some of their product directly to dealers. But when they sell through a distributor, they then have a sales force that's out in the country visiting all those dealers. So even though the distributor sold the product to a dealer, the Smith & Wesson salesperson then visits the dealer and then reports back like, yeah, dealer XYZ, they're really selling lots of this and they love our that, and they're doing these promotional activities. They're really good. And so the manufacturer does know what's going on in those dealers. If there's one that's really, really crooked, that's bad, that's, just use an analogy, that's putting off some kind of bad smell, the sales force for the manufacturer knows that.
Thank you. Any other, Christina?
Yeah, I was going to say, I think that those are, Ryan, giving that perspective from the of how those sales go, the manufacturers, the relationships between the distributors, etc. One thing that also really stuck out to me, and I feel like, as an advocate and working with these groups on the ground and doing this advocacy, at all levels of government, when we're talking about the Budweiser case and we're talking about Plaka, and the argument is always brought up, well, you don't sue a car manufacturer if somebody takes a car and kills somebody. So there is, to us, and this is a conversation that I would love to have our attorneys to be able to give some insight to, is what each of these different things were intended for use, right? So a car is intended for transportation. A beer is intended for consumption. Medication is intended for treatment. But a firearm is intended as a tool to take a life in a situation of war, to take a life for hunting, for consumption. So if we can, what is the difference there is kind of what I'm getting at. Because for a car, it's intended to transport, right? But the firearm is intended to take a life. So how can we as advocates and us as community members continue these conversations, when we're trying to get these things changed and close these loopholes?
Of course, the statute is the problem here. PLECA is specifically designed to avoid holding manufacturers accountable for just what you're talking about, the idea that the gun might end up killing someone. And isn't that horrible? That was really the intention all along of making a gun, that it might actually be used to harm someone, maybe for good reasons, by a police officer, or for bad reasons. But the whole point of PLECA was to say, no, manufacturers, you won't be held accountable for that, because that's just too obvious. You'd go out of business if that were the case. So that's why, in this case, we have exceptions in that statute. And that's why the government of Mexico has worked very hard to find a way to make its case within the exceptions, and at least get to the point where they can go to the evidentiary stage in this matter. Because right now they're just at the point where they have to say, technically, theoretically, we could make a case if we had the evidence. And the court's got to say, yeah, if we have the evidence, and what you're trying to say here would fit that exception. Unfortunately, what you're talking about is the other side of the case, which is, yeah, let's eliminate the statute. If there were a different political universe in which we live, and that would be the goal. At the moment, we're lucky we still have a court system. And who knows how much longer that'll last.
I think Paul's absolutely right. And that's what you heard even Justice Jackson saying sometimes, well, isn't this exactly what they were trying to prevent when they passed PLACA? But then she did come around at the end. And I think recognize that there is an exception and we have to give it value. And so I think the frustrating thing for all of you and for all of us is, this case is sort of playing at the margins, is trying to come within a narrow exception when the problem is PLCAA itself, the expiration of the assault weapons ban, and there was a lot of discussion in some of the briefing in the cases about the impact that had on trafficking to Mexico. So sort of those larger political choices that our country has unfortunately made over the last 20 years really make it hard to bring these cases and hold manufacturers responsible for the, very foreseeable, to use a word we heard a lot today, outcome of their products and the way they market them.
To pick up on that, and I think Christina's broader point, I think it goes to the way in which Justice Sotomayor was framing the proximate cause question and what degree of accountability and foreseeability or risk is applicable. And in particular, she said that she views that proximate cause question as better understood through what's called the third restatement framing, which is to say, is it within the risk? So is the harm suffered within the risk of the misconduct of the breaking of the law, as opposed to is it foreseeable? And while the court's precedents do line up with that foreseeability language, I think that frame is really very directly stated in the way you put it, Christina, and that and the way that Justice Sotomayor put it too, which is that the risk of an unlawful sale of a gun is criminal misuse of that gun, and that's very direct.
Thank you. We have a question here in the Q&A box that asks, the president agreed to work to end gun trafficking high-powered weapons into Mexico as part of the tariff deal with Mexico. Does anyone think this decision will give leverage to Mexico, and how can they use this decision to push the president to follow through?
That is a highly political question. And I think we all know that the current person in the White House is unreliable in what he says on any given day or minute. So who knows what that actually meant or what it would mean in the future.
I mean, I do think that the more extreme arguments that come out from the Trump administration as well as come out from the gun industry give Mexico more leverage in a sense, because they show that there's nothing else that will stop the gun industry. That the gun industry's arguments were basically like, look, it doesn't really matter even if almost all of our weapons are being trafficked into Mexico. That's not the issue here. Those types of arguments, I think, give Mexico more ground for the broader diplomatic negotiations in which the firearms trafficking and taking measures to stop firearms trafficking, whether those measures are in the marketing and production of the weapons or whether they are in enforcement. I think it does give Mexico at least more argument. Whether it gives more leverage or, I think remains to be seen.
Thank you. So I want to remind everyone that if you have any questions, feel free to put them in the Q&A box or the chat. But right now I'd like to jump into your calls to action. What should we be looking forward to as advocates and activists as we wait for a decision? We could start with Amanda.
Sure. So I see two things. One is on the political front, as we flag, some of these bigger battles we need to keep fighting them and win them to overturn the big laws that are preventing or get in the case of the assault weapons ban, get that back in place, to get real change on the ground. On the legal front, though, I think, it is important to bring these cases even when they face, as this one did, such long odds and trying to come in a narrow exception. It's important to, make the defendants respond to the claims, make them deal with the allegations, and just sort of keep chipping away in that sense. I think does have value even in times when, like this one, it's very tough both politically and legally to get the result you want.
Thank you. We'll turn to David.
I agree with all that again. And I think the other thing I would add, particularly for this group, that oral argument was obviously very clinical, and there was some light discussion of the harms. It was really kind of bypassed and abstracted in a legal way. And I think we cannot allow that to be the understanding of the harm that is suffered because of this crisis and because of this problem. And so I think every person who's been impacted and every person who knows someone who's been impacted and every person who has a platform to tell the stories of those who have been impacted should be doing that as much as we can.
Thank you. Paul?
Well, David, I appreciate that, especially in Amanda, outstanding thoughts. I mean, we have to keep fighting. We have to keep telling the stories. We have to keep sharing with people what's at stake here. And at the same time, I think we have laws that are out there that we can use more effectively if we promote them more too. That's why I work so hard with my nonprofit to educate people in Virginia and elsewhere about our emergency substantial risk order, which is also the extreme risk protection order in some states, or basically a red flag law. We do have laws that we can use to get guns out of the hands of people who are found by a judge to be a danger to themselves or others. We have other kinds of laws that can help us, and we have to effectively use what we have. Well, we still have a legal system that we can use to try to prevent as much harm as possible and hold people accountable where we can. We can't give up the larger fight, but we've got a big one ahead of us right now.
Very true. Ryan? I'm not sure if Ryan is still with us.
I think we may have lost Ryan.
Okay. John, would you like to give some insights and also maybe touch on that letter that you put in the chat?
Sure. I put in the chat just this morning, nearly 50 organizations from the United States and Mexico issued an open call to President Trump to take action against gun trafficking to Mexico, including issuing an executive order to take some of these guns off of the market. I often say when we're thinking about people who don't agree with us about guns, everybody has a line that they think should not be crossed, right? That line might be, well, do you think individuals have the right to own nuclear weapons? Well, no, I don't think anybody really thinks that. Do you think that individuals have the right to own tanks? Most people don't. Do you think individuals have the right to own like shoulder-fired missile launcher, missiles? Most people don't think so. So where is that line? Everyone has one. And then the question is, why did you draw the line there? And for us, I think that one of the important things that can come from that conversation is exactly what David was just talking about, is the impact on people that didn't come up that much in this hearing. But when we begin to count into the calculus the communities that are devastated, the families that are destroyed, the people who are still searching for people who are disappeared by people with guns, the ways in which people have been bankrupted by people with guns extorting them, then the gun market and the ways in which that market is regulated by law, that calculus changes. And so I think that's the conversation that we need to keep fomenting in our communities, in our contact, in our advocacy relationships, whose stories we listen to, who we spend time with, including those people who are directly impacted. I know some of them are listening today, and I know that they carry so much every single moment because of this gun market. So really glad for this conversation. Really grateful for the legal interpretation of the arguments that we heard, and hoping that people will continue to be in contact with each other and with all of us.
Thank you, John. On that note, I also want to say I'm the grassroots organizer with Stop U.S. Arms to Mexico, and this oral arguments listening party is just one example of the work that we do. We want to elevate the experiences of survivors from Mexico who are survivors of U.S.-sourced armed violence, and also really remind people that the guns that are killing us are the same guns. So please continue to reach out and work with us on this issue. I want to say thank you to all the attorneys who were involved in this call, also for your expertise, Ryan as well, Christina. We love having Community Justice as a wonderful partner, and all the advocates who turned in today and tuned in to listen to this oral arguments listening party with us. And with that, I will turn it back to Christine.
Thank you, Bella. And I echo all of those sentiments to everyone here on the panel and everyone who joined in the conversation. I am the Southwest Advocacy Associate for Community Justice, and we know that there is a correlation to community violence and this gun trafficking, especially for our Latino communities and Mexicano communities, as myself, having family on both sides of the border. Our calls to action are always to educate not only yourselves, but your community and your family members. Have these conversations. We don't have to only have these conversations via Zoom when there is a Supreme Court oral argument hearing. These are conversations that we can have with our neighbors to ensure that we are listening to understand and to try to find that commonality and that common ground to support our communities and our survivors. We know that this can happen anywhere. I come from a community where we were the first Texas mass shooting here in Santa Fe, Texas, and then unfortunately followed by my brothers and sisters in Uvalde, who then experienced exactly what we did. We know that these cycles of violence, are harming all of our communities, but there are so many things that we can do to try and mitigate that and bring an end to that and bring peace back to our communities. So definitely get involved, join a coalition. There are multiple national coalitions, there are statewide coalitions. Get involved in advocacy days and have conversations with your lawmakers and your legislators. And don't discount us gun owning families and gun owners. Definitely want to make sure that, for those of you that share in that community with myself and Ryan, we've got to be a part of these conversations and be the example of what a responsible gun owner is. And with that, everyone, thank you so much for joining. We will definitely be sending out some follow-up information, re-engaging with any kind of additional news or updates that we find out are ongoing as we're awaiting a decision for this case. So great to be with you, be in community with you today. Everyone stay hydrated, love your neighbor, and we will see you soon.